Good morning, everybody. It is Tuesday. It is the Courtroom Files live, a half an hour early. Welcome in. Let's start our day in Michigan, a snowy Michigan, from what I understand, and Judge Middleton.
Yes, sir.
We've met, but I need to identify you for the record. You've got a felony case. Let's take a look at that one. The felony complaint alleges that you were at the Walmart store where everybody hangs out on November 20th, and you did resist or obstruct Jacob Gardner with the Sturgis Police Department. Also Adam Kreitz, and you also allegedly committed a retail fraud. Resisting, obstructing, the two counts are felonies punishable by up to 2 years in prison and a fine of up to $2,000. You're also charged as a fourth habitual offender, which could make those up to 15 years imprisonment. Retail fraud stays as a misdemeanor, 93 days in jail maximum and a fine of $500 maximum. Mr. Joshua Robert, the Chief Assistant Prosecuting Attorney, is here, as well as your lawyer, Casey Strong. Mr. Robert, what's the status here?
There's a plea offer of attempt R&O and retail fraud third degree. The other counts will be dismissed. I believe he's going to enter a plea today.
All right, let's unpack that. Attempted resisting, obstructing is a misdemeanor, one count rather than two, and no habitual. The maximum would be up to a year in jail and a fine of up to $1,000. The retail fraud charge would be a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. You also have two city cases of trespass. It's alleged that on September 24th, you trespassed in the city of Sturgis, and again on September 24th. Those is how the city of Sturgis deals with its homeless problem. They charge everybody with trespass. The city attorney has offered to dismiss one of those if you pled to the other one and essentially just allow time served, which would be 11 days. Ms. Strong does not represent you in those matters, but she is here to make sure we're looking out for your rights. So we'll talk about that in a minute. Ms. Strong, you confirm the plea offer?
Yes, Your Honor.
Mr. Cisco, are you going to plead to attempted resisting, obstructing, and a retail fraud?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No.
Or promise you anything?
No.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Strong is here to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to be a witness on your own behalf. You'd have a right to take the witness stand and testify, but you don't have to because you have an absolute right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And finally, you'd have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. So let's start with the Walmart case. Were you at the Walmart store on November 20th?
Yes, Your Honor.
And let's blow this up so I can see it. Did you put some items in your jacket, some hand warmers, floodlight, and some bandanas?
Yes, Your Honor.
$172.26. So the police stopped you for that?
Yep.
And then did you scuffle with them?
Not at first.
But
There was
then,
only one officer that was there at the time. The other one showed up after I was already on the ground. After Gardner had me on the ground, the other officer came in and stuck his boot in my head and everything. So
all right. Now, you already had an attempt RNO earlier this year, and we're on a payment plan. Let me pull those up. Do we know what's going on with Giselle Gonzalez?
Was he the one that showed up late?
It's a she.
Oh, no, I don't know.
Is she even here?
No, I believe she's not.
You've been waiting all this time for that? I apologize.
No, that's okay. I wasn't sure how long this court gave defendants to show up.
I didn't realize she wasn't here. You're here for the village?
I am.
Well, I'm gonna issue a bench warrant for her arrest. She's got several other problems. She owes $1,124 worth of unpaid fines and costs. She has a probation violation hearing set in January. When I get those files, I'm gonna issue bench warrants for her arrest with a 48-hour hold and make you stay here for an hour. But no, she's not here, and thank you for coming down here on a snowy day.
No problem. Thank you, Your Honor.
Did the other translator case end up, did you?
What?
Oh, well,
Who?
the other translator case? I was told he came in late.
He came in late.
Okay.
And he pled to a generous plea.
I've got to step out for just a minute, guys. I'm going to leave you with Judge Middleton. I'll be right back.
Casey will send you a bill for that.
I'm sure she will.
Let's talk about these trespass things. They allegedly occurred on the same day. Where were you at?
living with my dad at the time.
All right, where were you trespassing? Well, let's take a look at those.
I was on Walmart and Myers,
All right,
just the property, just the parking lot in general.
and they told you not to come back there?
I'm not allowed in the store.
All right, so are you willing to admit to one of those if I dismiss the other one?
Yes, Your Honor.
We'll do 252141. So for 11 days, credit 11 days, concurrent with the other case. $125 or 2 days. That'll just get run out. Back in November, were you homeless then?
Yeah, I just recently.
Hand warmers and that kind of stuff is homeless behavior. But I'm troubled by this earlier R&O from earlier this year. Good morning, Sergeant Ball. Judge Middleton, could I see Nathan Deans in my courtroom? All right, thanks a lot. Bye. That'll take a few minutes to get him. Judge Pattison gave him 90 days. 6:04. That one allegedly occurred in April. And Matthew Barman and Brian Stuck and Aaron Moore. There was a competency exam.
Looks like that one stemmed also from his homelessness because he was in the Sturgis library sleeping.
I did that sentence. You already had 90 days credit after the evaluation, so I gave you 90 days credit, 90 days. Let you out of jail October in July. Mr. O'Bear, you got any thoughts on this case?
No, just the same as the court. It's his third attempt R&O conviction this year. He was also stealing. He's pled to 3 misdemeanors today, so I ask the court to take all of those things into consideration.
Ms. Strong, what would you like me to know?
Thank you, Your Honor. This is the only case that is before the court today. His previous case from April is not before the court. I would ask the court to look at this individually and recognize that the retail fraud did stem from homelessness. He was stealing items attempting to steal items that were reflective of his homeless status. The R&O, while he recognized his role in it, he did pull away his arm and was taken to the ground by officers. I would ask the court to consider his status and his time spent in custody and make a sentence that is reflective of the facts and circumstance of this case.
Yes, it appears to be more of a stiffening up, kind of resisting rather than punching or fighting with officers. On the retail fraud charge, I'm going to order 11 days credit, 11 days, and then waive the fines and costs. Concur with the attempted R&O. On the attempted R&O charge, as Mr. O'Bear points out, it's the third time this year you've been charged with this. Judge Noacker used to have a theory that if he didn't do a sanction, the cops would start taking their own sanction out on the street. Not good for anybody. I'm going to order 60 days jail, credit 11, leaving 49 days to serve. There will be good time calculated in there, but it's going to be warm and dry for the next 40 days or so. Fine is $0, $75 crime victims' rights fee, and a $50 state minimum fee, $125 or 2 additional days. You can't keep going to these places. You go there because that's where the stuff is. But you made such a nuisance of yourself, they barred you from both of the major retailers in town. And then you come, the cops got to deal with you. People get hurt, they get their fingers broken, or you get hurt. I'm going to give you some clean time and some warm and dry time. You'll get out sometime in January, Mr. Cisco. You're good to go.
Okay, everybody, once again, welcome. Happy Tuesday. Welcome. It's the Courtroom Files Live. I said welcome twice. So, yeah, like I said in the pre-show, I think I've only slept about 90 minutes. So you're all going to bear with me today. It'll be a fun ride. Let's go to Florida. Wade Mercer, first appearances.
Ms. Sellers, good morning. Ms. Sellers, Ms. Colbreth with the Sheriff's Department is here, ma'am. She's been working diligently trying to find a program for you. So I've been advised that I think they may have found a program, and I'm going to ask that you listen to Mr. McDaniel, and then we'll see if Ms. Colbreth has anything to add, Ms. Sellers, to what the plan may be. Mr. McDaniel?
Judge, we had discussed this before. We actually paid for her to get her psych examination done. She was admitted to it already. She was admitted to it prior to we had done it. We were just waiting for a seat place to open up for her. So at this point in time, we'd ask the court to amend the sentence to a probation sentence. She'd be allowed to go to the program in Sarasota. I believe the sheriff's office is going to be transporting, Ms. Colbert will be transporting her at her first available opportunity, with some conditions that the court puts on her, that she would obviously remain in the program, and that she go to aftercare as they required her to go to, and even in person aftercare, until the court deems that she's ready to be released.
Okay. Ms. Colbert, do you mind coming up, please, so we make sure that she can hear you? So Ms. Colbert, I don't know this is a program I've ever used. I'm pretty sure I haven't. I was not part of most of the conversations about this until today is the first time I saw the name of the program. I know there was a plan to try to find a program for you, but Ms. Colbert has some details on the program and how long it is. I just want to make sure you fully understand what you're committing to, Ms. Sellers. So listen to Ms. Colbert as she explains the name of the program. Let's start with that, Ms. Colbert.
It's a first step of Sarasota seasons, because they have different types of the program, different. So it's the seasons portion, which is anywhere from 30 to 90 days. And she and I discussed all of this yesterday. And then whatever aftercare that they just like care would be here, the outpatient services, but you will go to a sober living facility that they find you, and you will still continue to participate in any aftercare. And like I told you yesterday, you know, they'll, in the sober living, you'll get a job and all that thing, so we can get you closer to being a, you know, productive member of society.
Okay, so Ms. Sellers, you understand you'll complete the program, then you'll go to an aftercare inpatient program that's a sober living facility, and you'll be there for some period of time. And then when you complete everything, as long as you complete everything, that's going to satisfy the terms of your probation. You understand that?
Yes, sir, I understand.
Okay. Do you also understand that if you leave the program, or if you don't complete it, or if you get kicked out for violating their rules, then that also violates the terms of your probation, and you can be sentenced up to the maximum for the charge you're on probation for, which is a year in jail, 11 months and 29 days in jail. Do you understand that?
Yes, sir, I understand.
So your options are, number one, just finish the sentence you've already got. You've been sentenced to 9 months in jail. You have some credit. That's the option you have. Option two is to go to this program, if this is what you want to do, and go with it with the mindset that you're going to complete it. If you violate it, you need to understand it. If you get kicked out or if you leave, you don't get credit for the time you were in the program towards the jail sentence. You only get credit for the time that you're in jail. So the time that you've done in jail, you get credit for that. But if you stay in this program 3 months and then you leave, you don't get credit for that 3 months if and when I sentence you to jail for violation of probation, if that were to happen. I want you to complete it. I just want you to fully understand what you're committing to. Ms. Sellers, do you have any questions?
No, sir.
Mr. Goodson, is that clear for you?
Yes, sir. So she'll be placed on probation today if she agrees to the sentence. So my question is, will she be leaving today or?
No, so once we get the court order, I send that to the program, and they tell me when she can come, which should be soon.
So she will remain in custody until then, or
Yes.
she's getting out today?
She'll remain in custody.
It'd be bars to bed.
So as far as court costs and probation fees, are we going to collect those, or if she's in inpatient treatment? I know normally they're on conditional release, they're not on probation. So how do you want to address the?
Okay, well, let's find out if the court costs have been worked off at the jail yet, because she's already been serving a sentence. So Corporal, I'm gonna need to know, does she still owe court costs and fines from her original sentence, or has she worked them all?
Let me go look. She probably has got them close to being worked, if not worked off entirely, I suspect, Your Honor, because she's been in custody for the last month, so.
Okay, there's some specific language that they suggested be in the probation order. Ms. Corbett, Mr. Goodson is gonna need that language, and I think it's what she put on the record, that she successfully completed the inpatient portion and the aftercare portion, which includes the sober living facility.
Yes, sir.
She's got to complete all of that.
You would agree to complete an inpatient treatment program at first step of Sarasota Seasons and also complete the aftercare portion of the program?
Yes.
Yes.
Okay. So we're going to figure out the court costs and fines. While we're waiting on that, Ms. Sellers, do you have any questions about this?
No, sir.
Okay. And is this what you want to do, ma'am? Do you want to modify your sentence and give you a shot at this?
No, sir, I'd like to take this chance.
Yeah, she wants
You do want to go. I mean, I was
Yes,
probably,
sir. Yes, sir.
that question wasn't worded very well. You do want to go to the program, correct?
Yes, sir, I do.
Okay. So what I'm going to do is I'm going to modify your sentence. Actually, I need to check Mr. Mitchell, make sure it's okay with him before I do that. Mr. Mitchell, any objection to this? I know that you were kind of on board from the beginning with this. Is this okay with the state?
Yes, this is agreeable with the state, Your Honor.
Thank you, Mr. Mitchell. So we're going to amend the sentence to change it from the jail sentence to 11 months and 29 days probation. Standard court costs and fines are imposed still the same as they were previously. It's probably 370. Is that right, Don? We're going to find out if you've got any credit for payment of some or all of that in just a second. Corporal, know the answer to that question yet?
Yes, sir. She has paid off her fines.
Perfect. Fines and court costs are taken care of. As long as you're in the program, I'm going to waive the cost of supervision fee. So all you're going to do is you're on probation technically, but the only condition of probation is you stay in that program and you successfully complete it. And that program hopefully will be able to give Mr. Goodson some periodic reports on how you're doing. The other thing we'll want in there is that if she does violate the conditions of the program, get kicked out or leaves the program, probation officer be notified immediately. So Ms. Sellers, as you heard Ms. Corbett say, we're going to get you down to that program. Ms. Corbett's going to get you transported hopefully in the next several days, ma'am. And everybody here wants you to succeed at this, ma'am, and hopefully get on a better track in the last few months. Maybe this will get you straightened out, we hope. Do you have any questions at all?
No, sir, I don't have any questions.
Ms. Colbert?
So I do want to let you know that I have spoke to your grandma, and we've already gotten all your stuff, or she already has all your stuff together. So once I'm able to take you, like, everything's pretty much ready to go. So, and your grandmother is definitely on board for all of this. I've been in contact with her too.
Stephanie, would
Mr.
you,
McDaniel, anything?
Because I had another recent. So.
Stephanie, would you talk to the grandmother if you don't mind and see if she has some more of her medications? Because she ran out of it yesterday and she's going to go backwards if she don't continue to take her medication.
Okay, I will definitely make a phone call.
Anything else, Mr. McDaniel?
Nothing else, Sean.
Mr. Goodson?
So when she originally pled, she got 9 months on the resisting and 60 days on the breach of the peace. So we're gonna do 11 months, 29 days. I assume she's going in there to plea a nolo contendere, 11 months, 29 days to the resisting, 6 months to the breach of peace.
She's already pled, so she's not in another plea. We're just amending the sentence. Mr. Mitchell, for clarification, any objection to just changing the second-degree misdemeanor to time served?
No objection, Your Honor.
So that'll just clean that up. So the second-degree misdemeanor will be a time served sentence. That just means the second-degree misdemeanor breach of the peace is over and done with. Nothing changes about what we told you today. You still got that first-degree misdemeanor that you've got to complete the program. Mr. Mitchell, anything else from the state?
Nothing from the state.
Do you have any questions at all, Ms. Sellers?
No, sir.
I wish you the best, ma'am.
All right, thank you.
Thank you. Thank you, Ms. Colbert, for all your work in this case.
Officer, Ms. Sellers, could they go ahead and bring her up this morning and we instruct her that way when there is a bed available that we won't have to do that?
Thank you. So Corporal, if they can bring her up after first appearance and get her instructed, Mr. Goodson will get her instructed quickly on the condition of probation. That way she knows what she's got to do and she has all the rules in writing, then y'all can take her back to the jail if that's okay.
Yes, sir.
Thank you, sir. Okay, so that's it for friends or family in the courtroom. Let's go back to the top of our list, which appears to be Daquarius Smith. Sorry. Thank you. No, that's trash. I'm not gonna do those anymore. It's just, it creates more questions than it does anything else. Mr. Smith, good morning. Mr. Smith, you're here on an out-of-county warrant out of Washington County. I took a look at it, Mr. Smith. It appears to be a violation of probation warrant signed by, I believe that's Judge Register's signature, and it has no bond. Mr. Smith, what that means is you're going to be held for Washington County. You get over there in the next several days, possibly today, but also could be in the next couple of days. When you get there, you'll go to another first appearance, but the warrant I've got shows no bond. Do you have any questions?
No, sir. I appreciate you.
Yes, sir. Wish you the best. Keyshawn Jenkins.
Good morning, Mr.
Mr.
Mercer.
Jenkins, good morning. Mr. Jenkins, you've had a couple of issues. You had a fugitive warrant from Houston County, Alabama for what they say is multiple warrants. I'm not sure what their charges are. Then in Florida, you're accused of one count of driving with no valid driver's license and one count of fleeing and eluding with disregard to safety of persons or property. I had a question about probable cause on this, so I texted the attorneys this morning and asked them to look at that issue. Mr. McDaniel has sent some case law since I've got upstairs, so I haven't had a chance to look at it. Mr. McDaniel, what was your research show?
Any officer, as long as they're sworn, is reliable, if it's from a sworn officer. And I don't think we're going to be objecting to it come from a sworn officer.
Okay, so for probable cause purposes only, you're not contesting probable cause, Mr. McDaniel?
Correct, Your Honor. And I think those
Mr.
charges
Mitchell,
out of Alabama are all related to the same charge, same kind of charge, same charges.
And then another,
I'll give you a chance to ask questions in just a second, but I don't want you to say anything to hurt yourself. Mr. Mitchell, anything from the state on the bond on the other two counts?
On the other two counts, we would just request that since he doesn't have a valid license and this was a fleeing charge, that one of his conditions be no driving.
Okay. So Mr. Jenkins, what I'm gonna do is set your bond at $5,000 on the fleeing, on the no valid driver's license, $10,000 on the fleeing and eluding. So your Florida charges bonds is $15,000. You do have a condition not to drive a motor vehicle, but as Mr. McDaniel was saying, sometimes the state may elect to let Alabama handle everything. If they do that, your Florida charges might be dismissed and you go to Alabama and deal with everything. It's also possible the Florida State Attorney's Office will decide to keep the Florida charges here. That's their call. So we'll see what happens once they get a chance to review everything. Right now, you've got a bond in Florida. You don't have a bond in Alabama that I'm aware of, and we'll see what happens. If you post the bond in Florida, which you have the right to do, if you do post a bond in Florida, you'll come back to first appearance to talk about a waiver of extradition to Alabama. If you
Yes,
don't
sir.
post a bond in Florida, then we'll see what happens with the charges here first. Do you have any questions?
No, sir.
All right, sir. Have a good day.
You too.
So we do need to give him a notice for the court date tentatively for the 6th of
Yes.
December?
Yes.
No, it can't be December, January?
January.
I'm sorry. For January 6th, if we can give him notice for January 6th at 8:30, please. Corporal, we have Isaiah Lawrence. Mr. Lawrence, good morning. You've been accused of 2 charges, 1 count of grand theft between $750 and $5,000, 1 count of fraudulent use of a credit card. Mr. Lawrence, there is probable cause on the fraudulent use of a credit card. I had some questions about the grand theft, so I emailed the attorneys or texted them this morning, asking they take a look at that. And Mr. McDaniel, you may have sent a case on this one also before I took the bench. There's a separate statute for stealing a credit card, but the officer's not charged them with that. The officer's charged them with grand theft for stealing a credit card number is what they're accused of. And I don't know that I've always thought stealing a card was petty theft. But then if you use it, it's potentially a felony charge. Mr. McDaniel, what's your thoughts or position?
I have not had a chance to research it, but my general inclination is I think it's okay. I think that either this charge is going to be another felony charge out of 1760 that would be a felony charge as well if it was used like that. So I don't think I'm not sure it's going to make a difference.
Okay. So the question then is, are you stipulating the probable cause or not?
Correct. Yes,
For
Your Honor.
first appearance purposes. Okay.
Yes, Your Honor.
Mr. Mitchell, you agree for first appearance purposes, just go ahead and set a bond, because like Mr. McDaniel said, even if they charge the wrong statute, they can amend the statute.
For first appearances purposes, we're in agreement with that. I'll also be in touch with the investigator. He talked to me yesterday regarding Mr. Lawrence and actually he wanted to let the court know that Mr. Lawrence was very cooperative. He turned himself in on this case and then put up a fight. So he just wanted me to pass that along.
So let me make sure that I'm clear. My concern for the officer is what I think the law is going to say is stealing the credit card numbers is not a felony. It may be a misdemeanor like stealing a card would be, but then using it is a separate crime or possibly multiple crimes. But what this officer is trying to do is say when he stole it and then used it, that's grand theft for stealing and using it. And I don't think that's what the law is going to support that.
I'll be in touch with them.
That's my gut feeling and based on what my research. So Mr. Lawrence, let's talk about how we get you out of jail or whether I set you a bond. Mr. Lawrence, how old are you?
Yeah, 19.
And do you live by yourself? Do you live with someone?
I live with someone.
Who do you live with?
My cousin, uncle,
Who is your cousin?
Trayshawn Singleton.
Okay. So what is your relationship to the alleged victim, Miss Perry? Are you legally related to her?
That's my auntie.
That's his aunt.
Okay. At some point you lived with her. Is that right?
Yes, sir.
Okay. And Mr. Lawrence, you're not employed, but you have some type of income, correct?
Yes, sir.
Have you ever been charged with a crime before?
No, sir.
Mr. McDaniel, anything else on behalf of Mr. Lawrence for bond or conditional lease purposes?
Nothing, Your Honor.
Mr. Mitchell, what's the state's position?
I think we're about to see if we object or not object after you ask them this question. So
Your Honor, we just asked the court to consider a cash bond. I mean, he's local and he's not going nowhere, I don't believe, Your Honor.
Any objection to a cash bond?
no objection to it.
Mr. Lawrence, I'm going to set you a cash bond amount of $500 cash. You do have a condition of no contact with the alleged victim. The state and defense have stipulated the probable cause for these 2 charges for first appearance purposes only. You'll get to use the phone in a few minutes, sir. You post that cash bond, you'll be released. I'm going to ask the jail to give you a notice for January 6th. That'll be your circuit court date in front of Judge Garcia. And again, Mr. Lawrence, you'll use the phone shortly. Any questions, sir?
Yes, sir.
All right. Have a good day, sir.
Is that going to be listed as 250?
Yes, thank
for
you.
each
Let's
count?
to clarify that, we'll make it 250 each. It's still 500 total. Thank you.
James.
Yes, sir.
Next, we have James Lashley.
Hello, Judge Marshall.
No contact with the alleged victim. Is that that confusing? Mr. Lashley, good morning. Mr. Lashley, you're here because you've been accused of one count of driving while licensed, suspended or revoked. Mr. Lashley, there is probable cause for the charge. When I looked at your criminal history, I saw nothing prior to this. Have you ever been charged with a crime before this, Mr. Lashley?
No, sir. This is my first time I ever being in trouble or arrested.
Yeah. Okay, so Mr. Lashley, there is probable cause. I'm going to appoint the public defender's office to represent you. Mr. McDaniel is going to tell us whether there's an agreement reached or whether we're going to give you a court date or something else. Mr. McDaniel.
Your Honor, I spoke to Mr. Lashley. He's going to plead of no contest. The charges listed. You understand he'll be sentenced to 10 days in county jail. However, he won't serve that 10 days if he pays a $400 fine within 60 days. If he gets a valid license prior to paying the fine in 60 days, the fine will be $300. He has signed his two-way form with his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Lashley, did you hear that agreement?
Yes, sir, I did.
Do you have any questions about that agreement, sir?
Will I be able to bond out or anything?
We went through this one. Go ahead, Your Honor. I apologize.
No problem. If you get that question answered, you're going to get out of jail this morning and then you've got time to pay it and get it resolved. Any other
Yes, sir.
questions?
No, sir.
Is this a plea you would like to enter, Mr. Lashley?
Yes, sir.
Mr. Lashley, I'm going to accept your plea of no contest to the charge of driving while licensed, suspended or revoked knowingly. I'm going to find it's freely and voluntarily entered with the advice of counsel. Mr. Lashley, I'm going to withhold adjudication of guilt. I'm going to sentence you to 10 days in jail, but you will never serve that 10 days. As long as you pay the court costs and fines, you're going to get out of jail this morning and you have 60 days to pay the court costs and fines. If you don't get a license, the court costs and fines are $400. If you do get a license, the court costs and fines will be $300, provided you show proof of that license to the clerk. The due date, either way, with or without a license, it doesn't matter. The due date is February 2nd of 2026. So Mr. Lashley, you show up with that license, it saves you $100. That's what I'd rather you do, is get a license so that the problem is fixed. If you're not able to, you can pay the $400. Your disposition, which we're going to send to jail, has a court date on it of February 3rd. So let me explain that. Sometimes things come up and people can't get the court costs and fines paid. So what they do is I give them a court date. They come back the next day after it's due, in your case, February 3rd, and they say, Judge, I got half of it paid. I need another 2 weeks. I need another 3 weeks, whatever your situation may be. And I'll listen to you and I'll make a decision on whether you do just go and do the 10 days or I give you an extension. And frankly, a lot of times that comes down to what kind of effort you put into, getting it resolved. So Mr. Lashley, if you get it paid, you do not come to court on February 3rd. That court date is only if you need it. You're going to be released from jail this morning. Mr. Lashley, do you have any questions?
No, sir.
All right. Wish you the best, Mr. Lashley. Next is Robert Somnitz.
Froze.
Mr. McDaniel, your screen is frozen, so can you hear me? All right, so let's disconnect and reconnect and see if it works, Don.
It's Tech Issue Tuesday down in Florida. That happens sometimes. Good morning once again, everybody. Welcome to the Courtroom Files Live. Good to have you all here. While they figure out what's going on and if they can fix it, let's go to Texas. We'll say good morning to Judge West.
Good morning. Are you Adrian Hayward Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hayward, in cause number 24 DCCR 2149, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from May 23rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward is not competent?
No,
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols?
This is his first case that I'm showing, Your Honor. If he's going to be released on bond before sentencing, I'd ask, obviously, that no contact with the victim, he stay away from that address, that he not be allowed to possess a firearm. While the allegation isn't for using a firearm, there's allegation in the reports that he had brandished one that evening.
Okay. What's your relationship with Rihanna McLean?
My girlfriend.
It was your what?
Ex-girlfriend.
Your ex-girlfriend's cousin. So there's no reason for you to be around her, or it sounds like your ex-girlfriend at all, or anybody like that, right? So here's what I'm going to do. Based on the nature of your plea agreement, I'm going to reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have absolutely no contact or no communication in any way. That's obviously in person, but it's through social media or sending messages or anything with her. Do you understand? You can't go to an address where she is. If you're somewhere and she shows up, you have to leave. Do you understand? And then also, as a condition of your bond, you are not allowed to have any firearms at all. So if you own firearms, you need to get rid of them. If you have a family member that can take them, I don't care what you do with them, you can't have them or have them in your home or your car, okay? Any questions? All right, we'll see you back at sentencing.
Thank you, Your Honor.
Thank you. And then Jason Jones. Okay. Mr. Rojas, you have Jalen Hendricks sentencing.
Hey, Sharon, he's on the other end.
That's sentencing. Good morning. How are you?
Good, how are you?
Good.
This is for my other one. He just gave me that this morning.
This is for which one?
Mr. Yeoman. Yeah, there's another question.
Okay. Morning, Mr. Coleman. Would you put that with Leonard Yeoman's sentencing, please? I know. My nose is gonna start.
All right, friends, while they wait for the next contestant, let's just step across the hallway and say good morning to Judge Stevens.
So needed. Did you keep your eye on your dad on the desserts? I did. Okay. You gotta keep him honest. How's that working? It's harder than I say. Good days, bad days. Yes, sir. Okay. On Mr. Birdsong and all jocularity aside, this is serious. You're charged with the first degree felony of murder. And what are we doing today?
Dan asked me to fill in for him, the important Gasper, and he just wanted to see if we could get a reset since he was tied up there.
Is there the state wants to be heard on this? I'm sure. Anybody from the state at all on this murder case? There we go.
There's a murder case up there?
Yeah, it's yeah, serious things.
It's on discovery.
I understand. In fact, I'm not showing. I don't know who the prosecutor is on.
That's because I'm flying under the radar on this one, Judge.
I'm looking every resetting. There is no name for a prosecutor. But anyway, you're here.
I'm it.
They're asking for additional time. This is a case that we're going on 2 years, right?
Yes, sir.
So
I think we're getting close to if the next setting, if we don't work this out, we need to set it for trial. We need to do it, get it done. So.
Okay, resetting 5 weeks. Is that good? That puts you, it was in the first full week, it was in January.
Yes, sir.
And that build, kind of a fish or cut bait time.
Yes, sir.
Because, we're coming up on 2 years and that's time for a decision one way or the other on what direction they're heading.
I know we're waiting for a while for Mr. Walker to get a expert to look at things, and I think that's been accomplished. We just hadn't had a chance to go over and discuss what's been found and what we want to do. And that's partly because of schedule difficulties for both of us.
How old was the deceased at the time of death?
He was 70.
Okay. 5 weeks good?
Yes, sir.
Oh. Let me talk to the lawyer for just a second.
Okay, he's muted now, but this is a somewhat interesting case. Victim was 70. It makes me wonder, obviously we don't know the facts, it makes you wonder if this was like the guy's father or something, perhaps taking care of him and he's being accused of something. Obviously I'm speculating, I have no idea, but it kind of looks like it would line up like something like that. I'll keep an eye on this, but since they're muted, we'll step back across the hall again. Judge West has her next contestant.
You were previously here in cause numbers 23 DCCR 2323 and 25 DCCR 0574. Entered pleas of guilty in each of those cases to evading arrest or detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections?
Not from the defense, not from the state judge.
Mr. Hendricks, do you have a driver's license? No. Okay, so I'll explain what I'm going to do in a second. So I'm going to find Mr. Hendricks in each of your cases that you entered your pleas of guilty freely and voluntarily. And cause number 23, DCCR 2323, I'm going to follow the agreement you made and sentence you in accordance with it to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to serve 30 days in the county jail. You will get credit for that time since you've entered your plea. In cause number 25, DCCR 0574, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time follow the agreement and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're also ordered to pay a $500 fine to serve the 30 days in jail that you will get credit for, and follow all of the rules and conditions of probation. So the rules and conditions of probation are very important, because if you don't follow all of those rules, you're going to be right back in here looking at 10-year sentences. Do you understand? You've already agreed to 10 years. So part of your probation is going to be to get you the help that you need for whatever's going on. So you will be assessed for any type of mental health care, and you're ordered by me to follow any recommended treatment. That means medication, counseling, whatever it is. If they say you need it, I'm ordering you to do it. You understand? Also, you are not to drive any vehicle, period, ever, unless you have a driver's license. So you cannot drive. And then if you, and all the other regular conditions of probation, and the probation officer will go over that with you. If you do everything that you're supposed to on this probation, it's a great opportunity, because you'll be able to serve that 10-year sentence while you're on probation instead of in prison. But again, if you violate any of the conditions of probation, you will be right back in here and you'll be looking at that 10-year sentence in each of those cases. You understand? I'm handing you in each of your cases the trial court certifications. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thanks.
And then Lamone Yeoman, sentencing.
Yeoman?
Good morning, you're Lamone Yeoman Jr.
Good morning.
And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are you ready to go forward?
No, Your Honor, just ready to go forward.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the, because I believe you pled true, not true to number 7, which is failing to report. I do want to address those.
Okay.
I'm sorry, I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence to present on that count.
Okay. Let me get that pulled up. You may proceed.
Would you please?
I'm sorry, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th, you've not seen him since?
Until he was arrested, yes, sir.
So is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation.
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him you have a warrant, and he told me because it was his birthday, he was not coming to tell him.
Was there, are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother.
Okay.
And his mother told me that he was aware of the warrant.
I pass the witness.
Another questions for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Oh, yeah.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report, as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter, it's
I did
from,
not show it to Mr. Marcus.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out's better than being absconded. Anyway, all right. Anything else?
That's what the PSI.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in safe P. He did successfully finish the first part of safe P. The aftercare program is a part that he was kicked out of. He pled not true to count 1 as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of the roommates, one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. According to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today, is there? You haven't given your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that safety program. And that's what he's asking to give the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at safety, Mr. Yeoman is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings, 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally at what appears to be a week or two after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of while you're on probation for aggravated assault with a deadly weapon. You obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the ag assault, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's gonna keep giving me probation. I'm gonna come in, I'm gonna write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the baby.
Thank you, Your Honor.
Thank you. Thank you.
Okay, we'll continue to keep an eye there. Let's go back to Judge Mercer in Florida. They figured out their tech stuff.
Zoom and YouTube, as far as I can tell. Mr. Somnitz, good morning, sir. You're here because you've been accused of 1 count of petty theft. Mr. Somnitz, there is probable cause for the charge. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney, sir.
Your Honor, I've talked to Mr. Somnus. At this point, he's going to have no contest to charges listed. You understanding he'll be sentenced to 6 months probation, be a $370 fine, restitution not to exceed $12.06. He has signed his plea waiver form, waiving his right to jury trial and call witness. He can already terminate after 3 months if he gets everything paid off and completed. This will resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Somnus, did you hear that agreement?
Yes, sir.
Sir, do you have any questions about that agreement?
No, sir.
And Mr. Somnus, is that the plea that you would like to enter?
Yes, sir.
Do we say no contact with Walmart, Mr. McDaniel?
Well, he's got they put a no trespassing for 2 years on him, but no contact with any Walmart while you're on probation.
So, Mr. Somnus, I'm not sure if the no trespassing may have been only that Walmart. I have no idea. But for probation purposes, no contact with any Walmart, at least while you're on probation. After you're on probation, it's between you and them. Mr. Somnus, any questions about any of that?
No, sir.
Mr. Somnus, I'm going to accept your plea of no contest to the charge of petty theft, withhold adjudication of guilt, place you on probation for 6 months. Mr. Somnus, you'll have the standard conditions of probation plus the following special conditions: court costs and fines of $370, restitution which will not exceed $12.06. Some of the stuff, it looks like that they recover, but there was at least one food product in there, and sometimes they cannot restock food products. So there may not be any restitution. There may be a very, very small amount. We'll see. And there's by statute, there's a $3.50 clerk's fee per payment. Mr. McDaniel was going to say something.
I mean, they got it all back. There is the 83 cent or 87 cent for the ham or something. I mean, but hopefully Jake's not too worried, but I don't think Walmart's that worried about 83 cent. But
are you requesting restitution in this case, Mr. Mitchell? You shook your head no. If you're not requesting it, we'll resolve it right now. If you are, that's fine.
We can resolve it right now.
So you're
not requesting.
Okay, so there's not going to be any restitution. Mr. Mitchell's agreeing because of that amount, as well as because of the amount of probation that you're getting. The court costs and fines, restitution is really not going to accomplish a whole lot. So, Mr. Somnus, like Mr. McDaniel said, there's a possibility of getting off probation early. Mr. Goodson, anything else?
Is there a retail theft school mentioned?
Is there a retail theft school as part of the plea agreement?
I think it's part of it, yeah.
Okay, I'm being told two different things. So it wasn't on the disposition. It's almost always a part of every shoplifting. So, Mr. Mitchell, unless you are not wanting it, then I'm going to impose it, and we'll see if Mr. Somnus still wants to do the plea.
The state is requesting it.
Okay. Mr. Somnus, you do need to understand, if you enter this plea, there's a retail theft school, which is basically part of every shoplifting case we do. It's a 4-hour course. You can do it online. It's about how retail theft affects the economy and affects other people other than that particular store and that particular individual. So, Mr. Somnus, knowing there's going to be a retail theft school required, do you still want to enter this plea, sir?
Yes, sir. What does that cost?
It's less than $50, isn't it? 4-hour class, less than $50.
Yes, sir. That's fine.
Okay. All right. So, Mr. Somnus, just try to get everything done early so we can get you out probation early. What's going to happen next, sir, is they're going to let you use the phone. Then they're going to let you get dressed in your regular clothes. And the reason for using the phone is in case you need to set up transportation, because after you get dressed, they'll bring you to the courthouse. That's where the probation office is at, Mr. Somnus. And if you do call friends or family to pick you up, you can tell them you can be picked up at the Jackson County Probation Office, which is at the Jackson County Courthouse, in 30 to 45 minutes. Any questions, sir?
No, sir.
Have a good day, sir.
Thank you, sir.
Yes, sir. After Mr. Somnus, we have Kim Benson. Mr. Benson, good morning. Mr. Benson, you're here because the law enforcement agency, after your first appearance yesterday, has added an additional charge to you. They've now accused you of 1 count of theft from Lowe's. This allegedly occurred on September 29th. It's a different incident that you've already been first appeared for. I'm not real clear on what degree crime the officer intended to charge. They say theft, not grand theft. They check the misdemeanor with felony box, and it's just a little bit confusing. So I think there's probable cause for misdemeanor, first degree misdemeanor theft of more than $100, but retail theft, that is. Mr. Mitchell, any input or suggestion on probable cause first?
My take is that there's probable cause for a separate first degree misdemeanor petty theft.
Mr. McDaniel, any objection to that?
Oh, Your Honor.
So I'm gonna find probable cause for, even though it says felony on the first appearance, on the complaint, there's not probable cause for a felony. There's probable cause for a misdemeanor. I'm gonna set your bond in that case, Mr. Benson. What bond did I see to him yesterday on the felony charge or charges he had? Corporal, do you know?
25.
25?
Yes, Your Honor.
Was that a misdemeanor also?
It was a felony.
I said a $2,500 bond on a felony case?
I would say you said it, but you didn't say it. It was said over the weekend. He came back because they wanted to know.
Okay. You're right. He came back for the no contact portion. So Mr. Benson, your bond on this case is gonna be $2,500 cash or surety. You do have a condition, no contact with Lowe's. So just keep that in mind. It's a separate charge. That's why you've got a separate bond. Anytime your bond changes, you have the right to use the phone, Mr. Benson. So you'll get to use the phone in a few minutes, sir. Do you have any questions?
No, sir.
All right, sir. Wish you the best.
Your Honor, I want to go back to Robert Somnitz right quick.
Just a second. We do need to give him a notice. You want it for the misdemeanor court date in this case? We need to give him a notice for the misdemeanor court dates, Corporal, of January the 5th at 9 a.m. That'll be Mr. Benson's court date in this case, unless the state decides to do something different. Okay, you need to go back to who?
Robert Somnitz. After he left the room, I received a notification from Sergeant Lee with the sheriff's office saying that there are 8 more cases regarding him that she just received this morning.
So how does that change things?
There's probably going to be restitution in some of those other cases, so he may have to come back up at a future arraignment case and handle that.
You know how much that restitution is, Jake, or?
No, I haven't received them, and they were just received by the sheriff's office this morning.
So I don't know that anything we can do about it today. Yeah. What I'm gonna do is ask Mr. Goodson to let Mr. Somnitz know when he instructs him, or Mr. Ham, whoever's instructing him, that there may be other charges, but normally the state will try to collect restitution through his current case. And if they work that out with him, he may not have to pay restitution. So if you'll submit a proposed restitution order through Mr. Goodson, Mr. Goodson can present it to Mr. Somnitz. Either he agrees or he doesn't. If he doesn't agree, then you can charge him. If he does agree, then that's.
He will agree, Your Honor. I got his phone number and email address from him for that very issue, because he said that they had told him that there was other cases when they did some kind of search last night on facial recognition. And so I said, well, if that's the case, let me get your number and stuff. So I got his number and stuff, and I think he'll agree to eat restitution, the restitution, whatever that might be.
That's what Mr. Mitchell normally does with them.
Yeah.
Okay. Thank you. Thank you. And then we've got Mr. Collette. Mr. Collette, I asked that you be brought back after your life management evaluation. Your mother was here yesterday. She's not here this morning. And I think the reason I asked that you be brought back was just to give her an update and let her see where things stand, because she felt that you would benefit from a program. So the situation is the same as it was yesterday. Basically, we've got the evaluation back. I know they're recommending another evaluation with a more advanced degree person, perhaps a psychiatrist or a psychologist with a doctorate. So as of right now, your situation is the same as it was yesterday. You've got the bond that was been set for you. I'm still open to some type of facility if your family or Mr. McDaniel or Ms. Colbert with the Sheriff's Department is able to find an appropriate facility that you might benefit from. In the meantime, you've got the right to post a bond. Mr. McDaniel, anything else I may have missed in this case?
Just to remind him, he had an appointment. If he makes the bond, he's got an appointment. He had an appointment, so he just needs to go to life management and see them so they can adjust that appointment, because they made another one from him at the jail, I think, the 15th or the 17th or something. But if he does get out, he needs to go see life management so they can, accommodate that appointment for, if he's out.
Thank you. Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Collette, do you have any questions? No. All right. Wish you the best, sir. Mr. McDaniel, that's everything I had on my list. Anything else from?
All right, as they wrap it up, Barbara and Michael and Wahoo, thank you for gifting a membership. Ashley, thank you for gifting 2. Y'all making this old man feel emotional this morning, but I'm going to go ahead and blame it on the fact that I didn't really sleep. Seriously, though, I appreciate your generosity. Let's go back to Texas, Judge Stevens.
And on this one, what are we doing? It's keep coming with y'all on these. This is 2 serious cases today. What are we doing on this one today?
We're going to be asking the same thing, Judge. He's going to ask for a reset since he's out of the county. Right?
Okay. This one getting old. This one going. It's over 2 years on this. Invested. So What's state say? They're asking for 5 weeks. The previous case.
I don't have any objections to that, Judge.
Yeah, I think but it's probably run out of, the announcement times. Thanks. And John Panita Brown, I think.
Yes. Weeks.
Let's go.
Sorry, but first. I'm right there.
Barbara, thank you for the 5. Very much appreciate that. Ashley says, Dan, you help us get through the day, so it should be us that is appreciating you. Let's just say we all appreciate each other. Thank you.
In the process of repaying the victim, and the case is going to be dismissed after payment of all restitution. So we're just asking the court to reset while she's working on things.
When is that going to happen? It's already been 2 years.
They have
since it was.
Yeah, the problem with this is U-Haul, and they've actually entered into a settlement agreement with her on a civil basis. Mr. Boyd's aware of it. He's agreed to let them continue to do that rather than pay the restitution through the DA's office, because they file these things and then they still try to collect it through their collection agents.
I've got an email confirming how much is the sale amount.
They're saying they're accepting it over 9 payments. 9 monthly payments
over 270 days.
Yeah, that's 9 months.
Yeah.
So that's the payment schedule that they've agreed on.
Judge, I'll talk to him. What we'll do is if they've got a civil worked out and there's payment plan worked out and they've signed everything, we may just get rid of it anyway, let them just deal with it civilly. But I hate letting her just be able to just walk away from the civil agreement.
Well, also we're talking about dollar for dollar without an interest. These people have been without.
Yeah, and this is a reduced amount. I think this is saving her.
The September 29th to 23.
Yeah.
So it's been. You know what? Let me speak and then you can interrupt. That's what frustrates this court. It's one thing when you're charged with a theft and you pay it back over years, but when you pay it dollar for dollar, those people have lost the use of that money for years. Really, the right thing should be, you ought to be charged in interest, whatever the interest rate is at the time, added to the dollar for dollar. Because if you steal, let's say $10,000 from somebody and pay it over time, dollar for dollar, let's say over 2 or 3 years, they've lost 2 or 3 years use of that money and they're out. They still, if you paid them all back, the $10,000, they're out the use and interest that money would have served them. So just paying them back a little at a time over years, the flat amount that was misused or taken doesn't pay back the victim properly. They lost value of that money. And that's why when you go borrow money from a bank, you have to have interest. You have to pay interest. You may borrow 10,000, but it's going to cost you 10,000 plus the interest because the bank is losing that value and that worth. And that would apply not only to a bank, to anybody who loses money and then gets reimbursement. There ought to be interest charged, whatever the appropriate rate is at the time. But that's why this court has always been anxious when people pay it back. When you pay it back over years, dollar for dollar, they still lost money. And that's your fault.
Yes, sir.
Then how do you just apologizing to them? They want money back, but they just get dollar for dollar. That's why it's important that it gets paid back as soon as possible, because they're going to lose something. They're going to be a victim and they don't get repaid 100% of the loss of the use of the money. So when is this going to be completed?
They gave me 3 months.
to do it. I was gonna try and have it done in the next month. Maybe for income tax time, I don't know. But the thing is, they have me for theft of the vehicle. They said that I stole the whole unit. And at the beginning, we said that I didn't steal the whole unit. So after I pay it off, is that still gonna show up as a felony?
No, ma'am, the case is gonna be dismissed. The criminal case will be dismissed once you pay all the restitution.
Okay, so if I bring the settlement and pay them all before my court date.
Yeah. When it's done, all things being done properly as agreed, then they submit me a motion to dismiss the case and then it's dismissed. And that's why you can see it's a win for you, even though, you know, these people were out the money. But I am always concerned about the victims being paid back. And when you have to pay over years and it's just dollar for dollar, they're still out the use of that money for the period of time. They didn't get interest on it and they're out. That's why
Yeah.
it's important that people pay the money back as soon as possible. Okay.
It's not for us, it's for them. That's what we do with it if we got it.
So when's the next event? What do we want to set for a review? I mean, if she pays it back, if she pays it back, she doesn't need to come up here. I can dismiss the case. The quicker, the better for everybody.
Do it in about 60 or
But I'm
90
going to
days.
review
Make sure
it.
she's got time to do it.
60 to 90 days.
6 weeks to review it. Let's see where we are.
All right.
Get it reset. And Noah, Niemeyer,
27. Yeah. 27. Mr. Niemeyer is in Harris County Jail. So we need to reset till what do we need to do about getting him back here?
All right, well, they figure out their next contestant. Let's go back to Florida, but Judge Anna Garcia, it's been a couple weeks since we've seen her.
That is my concern.
Sir, here's, without looking at your score sheet, is he on for burglary of a dwelling?
No, ma'am.
Yes, Your Honor, third degree felony.
No,
So burglary of a structure, not dwelling. If it's third
Sorry,
degree.
it's grand theft of a dwelling, Your Honor.
Grand theft of a dwelling. So
Degree
does it
theft.
does it score?
He blows the third degree felony out of the water. He scores 68.4 months DOC.
Got it. So he scores more than the max on the third degree felony. I gotcha. Okay. All right. Listen, so is there anything else that you wanted to tell me? I want you to speak privately with your attorney. You will come back in just a few minutes whenever you've had that opportunity.
I don't want this attorney. ma'am.
Okay, so that's where I need to know why.
I don't feel he's working in my best interest, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right, you have indicated to me, you can put your hand down. I'm going to proceed with the Nelson hearing at this time. You have indicated to me that you believe your attorney does not have your best interest at heart. I will now hear testimony regarding why you think that is the case. And then I'm going to turn to your attorney and I'm going to ask for a response. Okay?
Yes, ma'am.
So what is it?
Well, the first time I saw my attorney, ma'am, he slept through the whole interview and his assistant was the one that did everything while he slept through the interview.
Okay.
The second time I saw him, he said, "This is ridiculous. You need help. We're going to get you a program." The third time I saw him was like he was opening my file for the very first time, ma'am. He told me out of his own mouth that I asked him, I said, "Why am I a violent felony offender when I've never had a violent felony offense on my record?" He looked at my case and he said, "Well, you have a child neglect. That's a violent felony offense." And I said, "No, sir, it's not." So he's trying to get me. He's not working for me. He's working for the prosecution, ma'am. And And I can't go with that. I'm sorry. I mean, it's a technical violation. And I want an opportunity to meet my conditions of probation.
I understand that you believe that your attorney is working with the prosecution, but do you understand that your attorney cannot control the plea?
Yes, ma'am. Yes, ma'am.
I promise you, every single public defender in here, if they could, would pick their own pleas.
But he hasn't even.
Now, I'm not
tried to-
saying
get a
that some of the other,
counter-
listen, I'm not saying that some of the other things that you've indicated are not concerning. Mr. Green, are you in a position to respond to the allegations that he has made today? Or would you like some time to regroup and get witnesses? I'm assuming there was another individual with you and that may be able to speak to the allegations, specifically the sleeping and so forth.
Your Honor, Ms. Porter was with me, and, you know, all we can do, the court knows, the violation of probation, and the state gives a recommended agreement if you want to enter the plea. Most of the time, and in his case too, we tried to get the state down from their plea for their original offer. And sometimes they do, sometimes they don't. And it basically, he didn't convey what their offer was, and he didn't like that. And so then he fired me. So I don't know. I can't make the state go down.
Sure. So he has indicated that you were asleep during the first meeting and that he met with your assistant essentially instead of you. Can you speak to those allegations?
Judge, I don't know. I may appear to have been asleep, but I know everything that was going on.
Okay.
I don't know what he perceived, and if he says I perceived I was asleep, I may have looked that way to him. I'm not going to deny that.
Sure.
But,
Okay.
I know what everything that's going on. Ms. Porter was with me, and she's been working this nearly as long as I have.
Sure.
But all we can do is convey the office of the state, and most of the time, sometimes they like it, most of the time they don't, and we try to get them to come down some. And then if they do, we make that offer to the defendant. If they don't want to take it, then we have a hearing.
I understand.
That's all I can do.
Then he has made one other allegation that at one point it appeared, because look, sir, the allegations about the plea, he can't change the plea. The state controls the plea, not your attorney. But there's one other allegation that on the third time that you met, that when you opened the file, he felt that was the first time you'd ever even looked at the file. Mr. Rogers, why did you feel that way?
Because he was looking for a reason why I was a violent felony offender. I said, why am I a violent felony offender when I've never committed a violent felony offense in my record ever?
And that's why it looked to you.
He started looking through the file and he found, oh, well, you have a child neglect. That's a violent felony offense. And I said, no, sir, it's not.
So that is the reason that you felt that was the first time he was looking at your file?
It is the first time that he opened my file.
Well, why do you say that? I mean, did he
Because
tell you that?
I watched him, ma'am.
Explain that to me. You had never seen him open a file in your presence before?
No, ma'am, I hadn't.
Okay.
He never opened my file in my presence until that day.
Okay. Do you wish to respond to that, Mr. Green? Or if you need time to consider the allegations, I'm happy to schedule this for a different day as well.
Judge, we'll just schedule for hearing and make sure that we get everything in we're supposed to.
All right. So let me ask this. The state is ready to proceed to an evidentiary hearing. How many witnesses have you noticed?
Just one, Your Honor. It's just an admission. He signed an admission to the positive UA.
So it's the local probation officer. Would you agree that this is an easy hearing to reschedule?
Yes, Your Honor.
All right. Is there any reason we can't conduct a continued Nelson hearing on Thursday or a different day if necessary for additional witnesses?
Yes, Judge, the state will be ready whenever the court or the defense need.
All right, let's do that. I will hear more and hear from any additional witnesses necessary to consider your allegations that you are unhappy with your current counsel. And that will currently be scheduled for Thursday morning at 9 a.m. If we need a different day because the additional witnesses need a different day, then we can do that. Okay. Do you have questions? In the meantime, your attorney will not work on your case because of the allegations that have been made until I make a determination whether he has been ineffective in representing you. Okay?
Yes, ma'am.
I'll see you Thursday morning at 9 a.m., sir.
Yes, ma'am.
Okay, thank you, sir. Let's cancel the hearing.
Thank you, Judge.
Okay?
So that's interesting. Michael and Lindsay both kind of think that the defendant is telling the truth and kind of siding with him. I kind of might be too. There might be something to that. Let's go back to Texas. 9 to 11% more. Judge Boyd, make that happen.
Edward.
Hello.
Hi.
How are you doing today?
I'm a little anxious.
All right.
I'm
Well,
doing good.
okay. What are you anxious about?
Well, just that you said that you were gonna release me today if I came back before you.
Well, no, I said we're
Upon-
going to get an update
Right.
for the MIC evaluation. Here's the thing.
Okay.
You're on probation, right?
Yes, ma'am.
And I don't want you to fail
Right.
at probation. The issue is that your MIC evaluation results are suggesting a TCOMI evaluation or and your appointment for the TCOMI evaluation probation. With TCOMI evaluations, it says that it's in March.
Yes.
Is there any way that we can see if Center for Healthcare Services will be able to take care of any mental health issues?
My understanding is they are backed up. I think March was the earliest.
But is she allowed to do Center for Healthcare Services or no?
I believe that they take walk-ins, so I don't think it's vital.
Judge, if I may add a few things on behalf of my client. Her fiance is here in the gallery, Judge, and I spoke to her before coming forward with you, Judge, and she is prepared to give some testimony regarding their plan as far as if Caitlin is released. When I first met Caitlin, she was coming out of being unstable, and she is obviously way stable now, more stable now. She's been on medication.
Well, let's call the fiance.
Okay, yes, Judge.
All right, the court is calling 2025 CR 013204 State versus Caitlin Nicole Jeffrey. Could I have parties announced for the record for the state?
Lauren Smith for the state.
And Jonathan Alvarado for the defense.
And are you Caitlin Jeffrey?
Yes, ma'am.
All right, the court has received the results of the MIC evaluation. The MIC evaluation is suggesting that there be, that she remain in custody for TCOMI. And in regards to the TCOMI evaluations, those have to be done in custody. They're telling me that their next available date for her would be March 31st, 2026. That's their recommendation. They're saying that the optional treatment plan would be Center for Healthcare Services. So you stated you have a witness?
Yes, Judge.
To speak to her stability?
Yes, Judge.
All right, call your witness.
Defense calls Danielle Hart.
All right, and if you'll step to this side, please. All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Danielle Hart.
All right, defense, you may proceed.
Thank you, Judge. Ms. Hart, you know we're here today for a probation hearing regarding Caitlin. Can you explain to the court who you are to Caitlin?
I'm her fiance.
How long have you known Caitlin?
A little over 2 years.
And are you aware of Caitlin's mental health issues?
Yes, I am.
How are you aware of that?
She has told me in her own words, I've experienced an onset of an episode as well as seen her when she is stable on her medication as well.
And when she's stable on medication, is she somebody who can function, be a normal person in society, be somebody who's not a threat to others and herself?
Correct. Yes, she was on her medication. She's fully functional, school full-time, work full-time, as well as holding a social life.
Now, regarding Caitlin's past, she's here today on a less than 1 gram Huntington-2 case, but she does have some prior cases. Is
Correct.
that fair? And isn't it true that she actually is on parole?
Yes.
Okay. And from what you told me and what Caitlin told me, she actually has a parole hearing next. Is that fair?
Yes, sir, on the 10th.
And is it your understanding, and obviously we don't know until the hearing,
Correct.
but that because she was granted probation in this case, that there is a strong likelihood she would continue on parole?
Yes.
With regards to if and when Caitlin is released, what are y'all's plans as far as keeping Caitlin stable in an instruction environment?
Well, I work from home. I own my own company. I work in marketing and consulting other businesses and helping them function properly. So I'm able to relocate. I'm planning on moving to San Antonio. For one, I'm the one person that she does trust to handle her affairs. She actually signed power of attorney over to me on her own accord and own suggestion upon this incarceration. We do plan on going to parole and probation, checking in, as well as she has opted to offer to go to Laurel Ridge upon release for a like a crisis care for a few days, just to get back on track with mental health, get the medication rolling again, continuing what she has here. I have seen a big difference, and she has well, between being incarcerated and now, as far as being stable on her medication. So we do plan on continuing the medication, and then her going back to work and school as well, once Laurel Ridge is finished.
And as far as work goes, y'all been able to obtain employment for her through, I think, your connections, or maybe with you, is that right?
No, it's through my friend. He has a few different companies, and he's extended a sales position to her, which would also work from home and allow her to, I guess, the flexibility to do everything that parole and probation requires her to do as well. It's an office job. He would supply her with the laptop and everything else that she needs for the job as well.
And going back a little bit, when this offense happened, who's she living with? Caitlin.
She was living with her mother.
Okay. And her mother actually came to court last time, is that right?
Yes.
And she's supportive of Caitlin, but my understanding is that upon release, y'all are gonna living separately. It's not gonna be like she's living with her mom. Is that fair?
So we would be living together as immediately
You
upon
would.
release. Correct. Yes. Mhm. And it would likely be at her mom's house. And
Okay,
Mhm.
at first, okay. And does the mom have any issue with that?
As far as we know, no.
Now, the court understandably is probably concerned that upon release, if TDRF is not put into place, that she could be unstable. Can
Correct.
you explain some of the things y'all have in mind? What will you be personally doing as far as helping with Caitlin staying on track and staying stable?
So I've been, I also have a friend with schizoaffective disorder, so I've dealt with this for a long time. I've also been attending NAMI courses out in Sugar Land in Houston, both online and in person, to help me become a better supportive spouse as well for her. As in reference to knowledge on the disorder, to help me learn how to deal with episodes as they begin. I've also learned that the cognitive behavior therapy is one of the best ones, because it teaches them how to not just stop, it doesn't necessarily stop the episode, but it teaches them ways to distract themselves when they feel the episode on onset, I guess is the best way to put it.
As far as you know, has Caitlin had something like that in her life?
No, she has not. This is the first time she has had somebody that is willing to help her tackle the mental health issue, which is the root of everything else, I believe.
I pass it, Judge.
Any questions?
Very briefly, so you stated that you and Caitlin have known each other for about 2 years, is that correct? Were y'all in a relationship on or about July 30th, 2000?
No.
Okay, so you met her prior to the incident,
Correct,
y'all were not
yes.
speaking in that time. Okay, where did you reside in July of 2025?
Sugar Land.
Sugar Land, where is that? 2025, you weren't taking a role to ensure Caitlin's stability, got that?
Correct, yes, ma'am.
So why the difference now versus that?
We were on and off for a while, and then she went into one of her episodes, completely cut me out. I know better than to push when it comes to that kind of disorder. But now that she is stable on her medication at the last time I saw her and spoke with her, she was not. And so, but this time, like I said, she willingly relinquished power of attorney over to me. And so I now have, I guess, over her affairs and can ensure that she can do what she needs to do.
So what are you going to do if Miss Jeffrey has an unstable episode and tries to push you out?
So, like I said, I've been taking classes, and one thing I've learned is to just talk calmly, rationally, not argue. And I have learned that it can get a little combative, but I've also learned how to, I guess, relieve that as well in the classes.
No further questions.
All right, I just have a few, any objections?
No, Judge.
All right. Where you all are planning to live, are there any minors in the home? What are their ages? 16? And what is?
Yeah, it's her daughter.
It's her daughter? And has Child Protective Services been involved?
Not that I'm aware of. No, ma'am.
All right, thank you.
You're welcome.
All right, if you'll come forward. So this is what I'm going to do. Her parole hearing is on December 10th. I've done parole hearings before. So sometimes when you have a parole hearing, the hearings officer will let you know, this is what I'm going to be recommending. Sometimes they don't. Usually whatever the hearing officer recommends is usually what ends up happening. So since your parole hearing is on December 10th, I'm going to recall this on December 18th, and I'll make my decision. What I can tell you, if parole continues you, then more likely than not, I'm going to want you to be set up with appointments for Center for Healthcare Services, because that is a long time to wait if she's stable. And counsel, what I'll need from you is a report from the jail that she's stable on her medications and she's actually med compliant. So of course you'll need to get a release from her and they'll give you the information. So if I receive information from you that she's med compliant, and if your hearings officer says we're going to continue you on parole, then more likely than not, I'll be releasing her to do treatment for Center for Healthcare Services. But if she doesn't follow through with Center for Healthcare Services, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am. I definitely will follow through.
All right, so you're going to be recalled back here on December 18th because I've been told that your parole hearing is on December 10th.
Yes, ma'am.
Because it would do me no good to say, we're going to release you for Center for Healthcare Services. Because if you have, we can go off the record, because if you have a parole hold, they're not going to release you anyway. And if they decide to revoke you on your parole, then you may not want to be on probation here, because when you leave parole, you'll be on probation.
Yes, ma'am.
I'm sorry, when you leave prison, you'll be on probation.
Yes, ma'am.
All right. Do you have any questions about anything?
No, thank you.
All right. You're welcome. We'll see you back on December 18th.
Yes, ma'am.
Judge.
You're welcome.
So based on the chat, I think Mike and I both have the same thoughts and same questions on this one. I'm just immediately was struck by the fact that she's known this person for 2 years. They're now engaged, and the one has power of attorney over the other. You know, you can make the argument that love is love. You love who you love, and you know, I get all of that. Trust me, I do. But there's also part of me that has to ask the question, what is she really getting out of this? And that's not a slight against the defendant. If she has mental health issues, obviously we want to get those taken care of. I'm very big on that here. I think our mental health system is incredibly broken. And maybe it is just love and she's going to be the great advocate. But to take over somebody's life that quickly, I have questions. I was going to move courts, but let's stay here. New contestant.
Waiting in line and parking. Trying to find parking right there.
All right. So here's the thing. In this court, docket starts at 9.
Okay.
So now you know the time crunch you have standing in line, you can calculate that.
Yes,
But
ma'am.
you need to be in court at 9. You understand?
Yes, ma'am.
All right. Where are we on discovery?
Your Honor, I believe we've got most of the discovery that is available at this time. And so we're pretty satisfied we got what is available so far.
State, were you able to tender an offer? All right, Ms. Ferguson. This is PTD. Can you give me a date for the last day in December to make sure that the application is completed? All right, we're going to be back here on December 18th. Make sure that you're on time, and counsel, just make sure the application is completed.
Yes, Your Honor, I completed it personally and turned it into the cage down the hall.
Oh, you've already completed it?
It's already complete, Judge.
Thank you.
You're ahead of
All
the
right,
curve.
Norma, then give me a different date for PTD. All right, then we will move you to January 5th.
Appreciate it. Thank you, Judge.
Thank you. So are you out of Bear County?
Yes, Your Honor, I'm in Bear County.
Okay,
Yeah.
all right. My first time meeting you. It's, Rudy. Okay.
Rudy Watier, Judge.
Watier. Ah, is that a Louisiana
It's a
connection?
French background. My grandparents are from Belgium. So.
Oh, wow. They don't consider themselves French though, right?
Well, there's a little bit of contention there, Judge, but at the end of the day, those quarters move all the time over there in Europe. So.
Oh, wow. Okay. Thank you. Well, have a good one. Once she signs the reset form, she's excused. Just have a seat and your attorney will bring the reset form to you.
Okay.
All right. Thank you.
All right, we'll stay in Texas. Go back to Judge West.
This morning, Your Honor.
Okay.
I'm not opposed.
Hold on a second. Good morning, you're Traylon Hill. Let's see, what is it?
It's a motion for continuance. By Mr. Matuska, Your Honor.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion is what I'm looking for. It may be one of the cases. All four. I just got a script error. Do I hit yes or no?
Yes, it's fine.
Sorry, now my computer's acting up. Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all of the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based
Don't talk, I'm gonna talk to you in a minute. Don't talk over people.
I'm not talking over him, let him know.
You're talking over me right
I
now
own
and you're
him.
talking over him.
I own him.
Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over
that
like
the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do that.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay?
Cool.
So
I
it's,
paid for Burbank. I don't even know who this is.
so
Y'all
you,
put this lawyer-
Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your lawyer.
You put up his file
I represent,
on TV.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is 'cause
listen,
I've been to court 14 times and I'm looking to go because I have no evidence on me.
listen,
during this whole entire
you
matter.
and me both are ready
So
for
y'all
you to
invaded
go.
y'all invaded
Both
my
of us are
community.
ready. Go back with the bailiff.
Y'all invaded my
Listen, if they
community.
come out to visit
All my
with you, you need to
constitutional
visit with
amendments
them.
y'all
Go back with the
made.
bailiff.
Hey, watch where you hold me, sir. Don't touch me like that, man. You ain't gotta touch me. I know how to walk, sir. All right, you just don't get it all.
Your Honor, after the evaluation, if there's maybe another way that we could.
So there's been a lot of debate in the chat the last couple of days, in the comments on various videos on this channel with regard to defendants who keep wanting to talk and keep wanting to talk, and the judge shuts them down. And a lot of people are saying that the judge is wrong for that, that they should be allowed to speak, that they should have their day in court, and things like that. Where I would argue that most of the time, there are times when the judges are just annoyed and want them to shut up, but most of the time they're just trying to protect them from themselves. Let me know your thoughts in the chat, but it's definitely been a debate that's been going on this channel. Let's go back to Judge Boyd, new contestant.
This is a motion to revoke?
It is, Judge.
All right. I don't have anything on the motion to revoke.
Here's the court summary, Judge. And specifically, Judge, this is a motion to set bond that I had filed on the motion to revoke.
Y'all discussed the motion to revoke?
I have, Judge.
So is this going to be contested?
At this point, it would be, Judge. The new number one is very new. I have not received the discovery as of yet.
Are there other allegations in the motion other than the new number one?
There are, Judge.
All right, Norma, set this for a contested hearing in 10 days. When is it set? All right, your contested hearing is going to be December 18th.
And Judge, on behalf of my client regarding the motion to set bond.
Oh, we'll hear that. I'll hear your motion to set bond, but y'all need to be ready for a contested hearing on December 18th. All right, did you file a motion for bond?
I did, Judge. I have it.
All right, thank you.
Judge.
State, are you ready to proceed?
Just 1 second, Judge. And I apologize, Judge. I'm agreeing with Megan, so. Okay, thank you.
All right, the court is calling 2022 CR 6828, State versus Alonzo Taylor. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Alonzo Miguel Taylor?
Yes, ma'am.
All right, this is a motion to revoke, and counsel, you're requesting a bond be set?
Correct, Judge.
All right. Have you all agreed on amount or no?
No, Judge.
All right, and defense, what amount of bond are you requesting?
Judge, in my review of the bonds that previously been set for this cases for this case, one was 10,000, one was 15,000. I would recommend Judge 30,000 as far as the bond goes. He does have a new number one. It's just one case to burglary habitation. And that case, Judge, his bond is already set at $75,000. So there's already a high amount. Given that, and given that it's on for a third degree, I would ask for 30,000.
All right, and state, what are you requesting?
Judge, I'm requesting $100,000 with full GPS and then no contact with some individuals. And I do have a state exhibit B1 for purposes of the hearing that I'd like the court to review and send in the vote.
All right, the court will review state's exhibit. Any objection?
Not for the purposes of this hearing.
Thank you. All right, the court has reviewed state's exhibits. Defense, do you have any witnesses to call with regards to bond amount?
Not at this time, Judge.
All right, then I don't know what he's able to afford. This is what the court is going to do. The court is going to set your bond at $150,000. There's going to be full GPS. There's to be no contact with the following: form.
All right. Unsatisfactory conclusion. Let's go. Stay in Texas, Judge Stevens. Let's go there.
Need to handle both of those matters and asking for.
We're gonna move forward one way or the other. We're gonna move forward. You can get whoever you need. When shall we be ready? I want a motion, begin the hearing. This was filed on August. We're moving fast.
Your Honor, we'll need to check on the case out of Jasper County.
Okay.
It has not been filed yet. They're still waiting on.
It doesn't matter.
Analysis there. It's going to take a while.
It doesn't have to be filed, you know.
No, but they're waiting on drug analysis. They can't prove the drug until the analysis is done.
It's at the labs. We don't know the status of it other than the lab has it, but we haven't gotten the lab results yet on that.
Okay. Well, why does the allegation say she committed an offense if we don't know if she did or not? I mean, somebody signed something.
As soon as an arrest is made.
I know that I know, but if you're not sure, it's one thing about it. I mean, if we're all held up because we don't know if it's a drug or not, how can you, in good faith, allege a crime?
I 100% agree with you, but that's always been the policy of the state.
When is this going to be known for sure?
Don't know.
I know I'm asking.
I'm not sure, Your Honor. I can check on it. Yes.
Because I want to move this when motions, there's no reason for motions to languish. We're going to work late if we have to, but we're going to move motions and they're not going to languish. After we're ready to move. And this,
Sorry.
okay, I'm looking at the administrative hearing and it doesn't even identify a drug. So the random urine screen was administered and was negative for illegal. She was advised any more violence. That was October 11th. That must be. We're talking about July 17th, 25. There's July 10th. Rated the offensive possession. Yeah. Then on inactive. It was arrested for new felony office. Offense. But yeah, that's odd. Generally, they identify a drug. There's something, some test that it would at least get summed up, but it's an unknown thing. That's odd.
We will try and look into seeing on the status of those lab results, Your Honor.
Okay, I want to reset it for 6 weeks. That's just. Okay, Elijah Watson.
You can stick around if you sign. You can stick around if you sign 3 cents.
Elijah Watson.
This is a relatively new case. I've talked to Mr. Watson. He's in the process of our attorney, so just asking for about 5 or 6 weeks set. So you can do that. It's a pretty new case.
Who are you hiring?
Miss Jennifer.
Miss Jennifer.
Jennifer Douglas, Port Arthur. Who's the person, that's the name he gave me, but he's also talked to other attorneys.
Okay, you're charged with a 3rd-degree felony of evading arrest, as you know, which carries with it up to 10 years in prison. So it's a serious situation. Okay, on October 28th, we reset this to today because he's trying to hire an attorney. When are you gonna not just talk about it, but do it?
Yes, sir. I was homeless for a little bit, and when I was trying to make the payment arrangement, she wanted it right then and there. And
Right now, you got a lawyer. Now, you can hire anybody you want, but we're not gonna wait on you. We're gonna move forward one way or the other. You've got a lawyer here, this man. And we're going to move forward. I'm going to reset this for an announcement, and in 6 weeks, and we're going to have an announcement one way or the other.
Question.
Okay?
You'll settle reset.
Yes. We're not going to wait on you. Christopher Clinton, Brian. This is so thick.
Well, we've been dealing with it for a while. This is the case that has the sex offender registration determination that is part of a civil case in Austin right now.
What do we do today?
There's not much we can do until that determination.
What do you want to do today?
I'd like to ask for 6 more weeks and we'll work on those.
What's the forecast on it?
Judge, there's a new district court judge in that court, unfortunately. So
Travis?
In Travis County, yes, Judge. Any of the statute requires us to litigate this issue in Travis County.
Glad you're here in Jefferson, where we have some control.
So hey, on the good side, Judge, this is the only one of these that you have. So
what? Tell me a little, just in a sentence or two. What's the deal on this as far as what are the options that can be headed toward?
The court could say, the district court over there in Travis County could say that he's not required to register as a sex offender because the statute under which he was convicted in Arkansas when he was 18 years old is not equivalent to the statute in Texas.
We don't accept.
In other words, he was convicted of a misdemeanor in Arkansas when he was 18 or 19. And what the DPS did was they are treating that like it's in second degree indecency with the child. And the two things are not the same thing. At least that's our argument. The district court may disagree with me about that, but the elements are different. The offense is different. The level is different.
Is the requirement that it be a felony or be defined as a sex offense?
Judge, the answer to the question is there is no requirement that it be a felony, but there are no felonies under or misdemeanors under Chapter 62. So do with that information what you want. But the real answer is, Judge, the offense for which
there a related crime?
I would say no.
The elements?
I would say no, and I'll tell you why. Because the offense for which he was accused was having consensual sex with someone within 3 years of his age, when she was 17 and he was 19 or 18 or whatever it was. And the gist of it is that in Arkansas was a misdemeanor sex offense. But in Texas, that wouldn't be an offense here.
Well, it would have a defense.
But if it meets all of the elements, it'd almost be a summary judgment defense. I mean, it would not be an offense, but certainly not what he was convicted of in Arkansas as a misdemeanor, certainly not the equivalent of indecency with a child or sexual assault of a child in Texas. It's just the elements are not the same. And what DPS has to do these charts for each state and say these crimes in this state equal these crimes in Texas. And our argument is when they did that chart, they did this one wrong as it relates to that offense in Arkansas. And then for whatever it's worth, to make things even more complicated, the legislature about 2 years after his conviction in Arkansas completely changed their whole penal code. And so now it's totally different, and that rule doesn't even exist anymore. That is not even a crime in Arkansas anymore, what he was convicted of.
Okay.
So
what do we want to reset?
I mean, 6 or 8 weeks, Judge.
Right.
Yeah.
All right. 7.
Thank you, Judge.
Good resetting.
Thank you.
Then that goes to Langston's case. Did anybody see Mr. Pollard at all? At all? Is he? He's blending in. He's blending in with the scenery. Is he here around?
He's here live and in color. It's live. That's just our first.
Hey, it's going on 1 year as an indictment. I mean, where's he been? What took so long?
I think I got the case in October when they assigned me to it.
Yeah, this isn't good though. He's got all those priors, huh? So is this habitual felon on 138? Looks like, I'm afraid.
Yes.
Yeah.
Right.
Then the state jail felony in 139 is going to be punished as though it were second degree. Is that right? What's that? You got sequential. You got 4 sequential priors. So this is serious. What do we do?
I think they're gonna give me some time. They got to convert the files so I can print them on the discovery portal. I think the DA's office is going to convert them for me. But this is my first appearance with him. I know the case is a year old. Like I said, I didn't get this until I believe October.
Oh.
Yeah.
All right. This is 6th resetting already. This is a 6th resetting already. Langston. I didn't matter. I mean, he can change lawyers every time, and then that would be his excuse. I got a new lawyer.
No, I think it's a technical issue.
We need to. We need technical issue. Is just he's changing lawyers, but the court's going to move forward. I mean, you don't have at least a year rule. There isn't anything. It's moving forward, and you want to keep changing lawyers. That's okay, but you're going to work on my speed, but not on yours. We're not going to do that on yours, Mr. Pollard. I went 4. He's got 4 weeks.
That's what
4. We'll just do what? 5 weeks. 5 weeks for a decision, what direction we're going to head in.
No, that's no problem.
Then we'll go that direction. Okay.
No problem.
And of course, we try it. It'll be, I guess, the unlawful possession of a firearm case. That's the one that's looking at life in prison. You're looking at a minimum of 25 years. Minimum of 25 years to life in prison on that one. And then the other cases, no less than 2, no more than 20 years confinement in prison on that. It's all because of prior convictions, which is what is the factor in the penalization is the circumstances of the crime and criminal history. Your criminal history is terrible. That's why it's always my advice to you is don't commit any more crimes. I should have given you that advice before you. Anything else? That is all. Okay, let's get ready to rumble.
Okay, so he just used the word penalization, and I pride myself on a fairly decent vocabulary, but had not heard that before. Thought he made it up? Nope, he did not. Penalization is the act of imposing a penalty or punishment. It sounds like you're taking the word penalty and making something up with it, but you are not. It's an actual word. Did not strike me that way. Let's continue in the South, but go back to Florida and Anna Garcia again.
Turn around. You may do so. Okay?
Yes, ma'am.
Okay.
On behalf of Mr. Wallace, we move to withdraw his former plea of not guilty and enter plea of no contest to violation of probation. Agreement with state subject to the court's approval is that he would be sentenced to 108 months in Department of Corrections. And I'm not sure how much this credit is going to be. 601, I believe.
660 is the credit.
Okay.
So what would that take me down to?
660 is almost 2 years, sir. 365. It's 2 months shy of 2 years. You have about 2 years credit. You may, Mr. Blunt.
For the record, that's just the jail credit, right?
Yeah.
He never went to prison.
Yes. I thought you went.
He never went to prison. He got probation from the get-go.
Yeah.
He had a good attorney. Sorry.
Huh?
He had a good attorney.
He had a very good attorney.
So
He never went to prison. He always went to supervision.
So
You never went to prison on these charges, correct?
yes, ma'am.
Mhm.
So
Thank
you. Whatever that I have to do.
108 minus 660 days, 108 months. Do you want, oh, I don't have a calculator. Do we have one, Jeanette? We used to have a little. So to summarize, the defense has indicated that Mr. Wallace wishes to withdraw his previous plea of denial and admit to the violation of supervision. The agreement is that there will be a revocation of the supervision, that he'd be adjudicated guilty, that he serve 108 months in the State Department of Corrections, and that he be given credit for 660 days that he's already served. There would be no probation to follow. And he'd be charged an additional $500 court costs, fines, and fees. All monetary obligations would be reduced to a civil judgment. State, is that the agreement?
It is, Your Honor.
Defense, do you stipulate to a factual basis for purposes of this admission? All right. $60 days.
668, 720, it's 2 years. So you'd be right there. 120 that. See, don't.
Mr. Wallace, did you hear the announcements that have been made about your resolution?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything else to get you to enter into this admission?
No, ma'am.
Is anyone threatening you?
No, ma'am.
All right. I have in front of me a one-page admission form. Did you sign that document right there?
Yes, ma'am.
Did you have enough time to review the document before you signed it?
Yes, ma'am.
Have you had enough time to talk to Mr. Green?
Yes, ma'am.
Are you satisfied with his advice and counsel?
Yes, ma'am.
Do you understand that by entering into this admission today, you are giving up your right to go to a VOP evidentiary hearing where the state has to prove that you violated the terms of your supervision?
Yes, ma'am.
Do you also understand that you're giving up your right to present any defenses that you may have?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
All right. Are you doing this of your own free will?
Yes, ma'am.
All right, Mr. Wallace, I find that your admission is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the admission. I will now proceed to sentencing unless I hear otherwise from either the state or from the defense. Mr. Wallace, in Jackson County Case Number 23 CF 499, I accept your admission of the violation of supervision. I'm going to revoke the terms of your supervision and sentence you to serve 108 months in the State Department of Corrections with credit for 660 days that you have already served towards that sentence. Once you are done with that prison sentence, there will be no probation to follow. However, you will still have to register as was previously ordered. I order you to pay an additional $500 court costs, fines, and fees. All of your unpaid monetary obligations shall be reduced to a civil judgment. Mr. Wallace, do you have any questions for me about the sentence that I have just imposed? Do you want me to recommend that you be housed near somewhere?
I would like to go to Swanee.
Swanee, CI?
Yes.
I will recommend that you be housed at Swanee CI. Mr. Wallace, that may or may not occur. It is just a recommendation. It is up to the Department of Corrections whether or not that ultimately occurs. All right?
Okay.
I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose, okay? Thank you, sir. We're going to need your fingerprints, and I wish you well.
I have to say, in the last 14, 15 months, whatever that I've been running this channel, I have watched a lot of court. I have never once heard a judge ask a defendant where they would like to be housed and then offer a recommendation to let that happen. It's new one on me. If you've heard it before, feel free to let me know in the chat, but I have not. Let's stay in the South. Let's go to Louisiana. Let's give the parole board a try.
Parole is now reconvening. We're at the State Police Barracks. It's Tuesday, December 2nd, 2025, and the time is 10:35 a.m. Captain, good morning. Would you introduce yourself for the record?
Yes, ma'am. Captain Patrick Washington, State Police Barracks. Ms. Lisa?
Oh, Lisa Prajon with classification.
All right, you're not solo today. Good. Well, thanks for having us today. And we have in front of us Mr. Is it Care?
Yes, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Tory Care. My DOC number is 224-264.
And we have some folks here. Well, you can see Mr. Myers on the Zoom. Also here with us in Baton Rouge. We have, well, your attorney, you have counsel here today. Would you introduce yourself for the record?
Yes, Grace Brunson, here for Mr. Tory Care.
Thank you. We also have Janice Bates, your mother, Sherry Jackson. She'll be speaking on your behalf. Deborah Henry, and also Quincy Bates, your father, is here. You see, we have Mr. Randall Meyer on Zoom. He's with the District Attorney's Office in Jefferson Parish, and then we have your daughter, Tori Mollison, who's also on Zoom. So your case has been assigned to me, so let me just read the information into the record. You've been through the process before, so you know how it works.
Yes, ma'am.
So you, Mr. Care, are classified as a second felony offender. You're currently serving a 40-year sentence. You were sentenced in Jefferson Parish in April 2006 for manslaughter conviction. Your parole eligibility date was February 24th of 2024, and you do have a mandatory good time release date, March 2nd, 2037. Is all that correct, sir?
Yes, ma'am.
So your case was assigned to me, so I'm going to take the lead. So first of all, we want to hear from you. What did you do to wind up in prison? I do see you had a hearing in October of 2023. You were denied because of the opposition that we'll restate today and your history of drug abuse. So what have you done since then to address those issues of concern?
Well, first and foremost, I would like to thank the board for this opportunity to be here. Again, my name is Tory Care. I'm a recovered addict. I've been incarcerated for 21 years, 10 months. I've been sober for 21 years, 10 months. I would like to say that I'm sorry to Shantae, James, Ingrid, Iron, our children, Tori, DeJaneiro, Jonquel, both sides of the family as well as the community. I admit that I was wrong. I allowed my actions, my troubled mind, to lead me to be reckless, selfish, inconsiderate, out of control. Each and every day, I think about the cause of what I've done. I regret all barriers that I caused inside their heart. God knows if I could take back what I did, I would. I'm deeply ashamed. Excuse me. I'm deeply ashamed for putting everyone through a devastating mindset, afflicting trauma, pain into their life. I pray that one day that God can forgive me for what I did. As a young kid, I grew up in poverty. The household I grew up in wasn't peaches and cream. A lot of things that I did see, I shouldn't have. And I believe it affected me the most. I started using drugs and alcohol at the age of 17, 18 years old. Not long after, I was selling drugs. I was selling, I was selling drugs to fund my own habit. Not long after, I was out of control by the time I was 34 years of age. I used drugs and alcohol to numb all failures and responsibility, and that affected my wife and my children the most. During that time, I didn't have a clue of any resources of getting help, and if there was, the people that I hung out with wouldn't have got it. As a man, I was too prideful to admit that I had an addiction. Excuse me. And I didn't confront that as well. Instead, I allowed drugs and alcohol to consume my life to where I made all the people that I love and cherish miserable. 2024, February the 24th, I was sitting in my home on my staircase. I was smoking crack cocaine, smoking weed, drinking hard liquor, when I heard a voice outside of my window. I got up, I went to my window, I looked out, I saw my neighbor, and I saw an unidentified male standing next to her. As I went down to open my door, there was nobody to be found. At that moment, I got a little paranoid because of the life I was living. So I proceeded to go back on my staircase and continue to drink, smoke crack, more than what I was doing that night. I used drugs and alcohol all the way up to that next morning. I could recall me approaching Shantae with all my insecurities and all the rest of my baggage that I had was going on. I asked her about what was going on. She had no idea what I was talking about, because when I approached Shantae, I was aggressive, I was outraged, and I just wanted answers. We went back and forth. We started arguing real heavily. I allowed myself for that argument to escalate. At that moment, I grabbed the knife. I lost control. I asked my kids to get out of the room. The argument, I escalated, continued. We went back and forth, forward and back. And that's when I heard I swung the knife at Shantae. Then I heard Tori asking for us to stop. I pushed Tori out of the way. I swung the knife at Shantae. Shantae rushed toward me to try to retrieve the knife from me. We struggled for a moment. That's when I got a strong hold with Shantae, and that's which led me to stab Shantae multiple times. Shantae fell to the bed, I dropped the knife to my side. I realized what I have done. I knew what I did. It was wrong. I grabbed Shantae, I put her on my legs and hold her on my chest. And I told her that she would be okay. Moments later, I could recall hearing the sirens. And I panicked and I laid Shantae next to the pillow. I left out the room like the coward that I was. I didn't stay to help her. I should have, but I didn't. I went to the neighbor's house where I was later arrested. And I was told that Shantae had passed away. At that moment, I knew I had a serious addiction. I knew I had to take responsibilities, to take whatever steps I had to take to change. I confessed to what I did. I gave the statement to the detective. And later, I received 40 years. I had time to think about what I've done and came to an understanding, which led me to put all my imperfect behind me and get some help. I've taken multiple classes as well as self-programs. I learned that any substance abuse is a complex cycle which causes problems, actions, and consequences. I had to de-escalate these problems by self-change, recognize risk, and paying attention. I also took a class, anger management, and I learned that anger management is an emotion. And to control your emotions, you have to replace old thinking patterns with the new ones. The one I got out the most was victim awareness. I learned that physical emotion, mental harm, any action caused to the victim, the family, the children, becomes a secondary impact. I had to learn empathy, learning to understand what I have done, the choice that I made to cause every suffering that I proceed to do with my loved ones. All these classes, they helped me to become the man that I am today, to express what I never learned how to do as a kid, to express my feelings, to put people first, to honor and cherish my sobriety, as well as making better decisions, becoming the man that I am today. I'm seeking parole today because I know who I am now, I know who I were, and I know who I will be tomorrow. I'm no longer a liability, nor a threat to the public. I have trustworthy jobs at the training academy. I work for the state police as well as the cadets. I do interact with all different types of law enforcement throughout Louisiana. I have a great support system. My family, my children. I also have an active sponsor, a spiritual advisor. And if I'm granted, I will be going to the parole to get further assistance to help me with job training, technology, and et cetera things. I also took another program that will help me with the same curriculums. It's called FOM Fathers on a Mission. I'm here today asking the parole to give me a second chance, have mercy, to where I can finish my sentence on parole. I want to prove to the parole board, my children, my family, the community, that I can be an excess achiever in society. Again, I would like to say that I'm sorry. James, Aaron, Ingrid, Tori, De Janeiro, Jonquel, both sides of my families, as well as the community. Thank you.
All right, I'll have some questions for you in a little while. Captain, what can you tell us about Mr. Pear?
Good morning again, you all. Tori's been here for 3.5 years. In that time, he's done an excellent job working for us. He currently works, as he said, at the Training Academy, and he's around all of the employees at the State Police Academy, and we have nothing but positive things to say about his work ethic.
Thank you, sir. So we'll hear from the folks that want to speak on your behalf. Could we first hear from Mr. Myers with the Parole Project?
Yes, good morning. Kerry Myers with Louisiana Parole Project. We were here for Tori at his last hearing. We continue to be here for Tori. One of the things I think that is evident is his remorse is genuine. And I think that reflects everything about Tori. He's genuine. He understands that his addictions led to his actions, and he has continuously taken steps to address that particular issue, his addictions. He's committed to his sobriety. He's committed in the future. He's been committed while he's incarcerated to his sobriety. Parole Project will help him through his transition. We'll obviously take him into transitional housing. We'll provide him with support systems, a case manager, and mentorship. We'll help him with technology and financial matters. He'll also be evaluated by our social workers, and particularly with his addiction issues. While we believe he is actually, I think his plan already is pretty comprehensive about his sobriety, about having a sponsor. We'll continue to evaluate that and work with him in that. The maturity he's shown at the age he is now, we think he's an excellent candidate. I think his character comes through in his sincerity. We believe that Tori is an excellent candidate for parole, and we just ask this board to grant us parole today.
All right, thank you. So here we have Ms. Sherry Jackson. Could we hear from you now?
Good morning, members of the board. My name is Sherry Jackson, and Tori Pear's sister. I work for a nonprofit organization, just got Chairs Diocese of New Orleans. I've been there for 3 years. Married. My husband is in law enforcement also in the police department. He's been on this job for 37 years. We have 3 kids. My oldest, which is my niece and my godchild, who I raised with my husband since she was 22 months old. She has a 7-year-old child. My oldest son, he has a 13-year-old grandson. And my daughter is expecting her first child at the end of her husband. First, I want to begin by acknowledging the immense pain and loss that Shantae's family and loved ones have endured. There are no words that can take back the tragedy or the loss that my brother has endured. My family holds them in our thoughts and prayers every single day. Over the years, I've seen my brother truly accept responsibility for what he did. He has shown genuine remorse, not just through words, but through actions. He has participated in management, self-esteem, think for change. He's in the work release program. He's received his forklift and GED certificate. He knows his consequences of his actions, and he's working hard to become a better person. I'm not here to excuse what he did. I believe in responsibilities, I believe in change, and I believe in redemption. And every person can learn from their worst choices. Granted parole, our family will continue to support him with his rehabilitation and reintegration into society. Thank you for allowing me to speak, and thank you for considering this case.
Thank you. We appreciate you a lot. And so we have Mr. Bates Senior.
Yes. Good morning.
Good morning.
My name is Clancy Bates. I am Tory father. Me and Janice been married for 51 years, me and my wife. When Tory was born, I went to the hospital and picked him up in 1969. He have always been, and trust me, obedient child. What happened to him, it take God to tell me. I never would have thought where I raised my child. He's a good child. He's a good man that did a bad thing, a shameful thing. And he come around to his actions. He know what he did. And I told him it was shameful and it was wrong. My grandchildren suffered just like me and my wife and his sisters. We have suffered for 20-something years. I haven't had a decent night's sleep since my son been incarcerated. He's a good man. I told him I wasn't going to sugarcoat nothing for him and I won't lie for him. And he know that. At one time, when I was working, he got out of school. I had a job for TLJ Construction Company. I built a bridge, I-310, from north to south. Every deck I built for TLJ Construction Company. I had to have 15 minutes. One of them was Tory. He was a smart, no attitude, wasn't afraid to get his hands dirty or his feet. I brought him out there, him and his brother. He made it. My other son didn't. I had to let him go because he couldn't do the work. Tory's a good man, trust me. If you let him out of here, give him a second chance. Ever who hired him, are a good man. A man that would work. I done tested it. I worked him. When I went to farmers meeting, when I went to classes, went on the job to check the job out for what I was doing with 15 men and my son, he was my lead man. When I walked off the job, he took control. Supervising men, 50 older than me. He's a good man. He's a hard worker. And who hired him, if y'all cut him loose, he would make a good employee and a good neighbor. What he did here does not reflect the way I raised my children, my daughters, and my grandchildren. I love every one of them. I got over 15, 20 grandchildren. And I know every one of them. I love them, I help them. What Tory did was shameful. I love my grandkids. And guess what? They love me too. Before all of this happened, they would come by my house on the weekend, go in my backyard, I grow plants. And Tory liked to grow plants, which is good. He would take some of my plants. I wouldn't tell him nothing. He'd walk out there with him, you know what I'm saying? Go home, set his house up. Every now and then I would go there. I felt like I'm responsible for certain things that happened in life because I wasn't there enough. Even though I took them fishing, I took them hunting, I got them jobs when they got grown, I cleaned them when they was babies. I did all of the things that a father and a grandfather could do, and I'm proud of them. I did not desert them. I gave him a chance. And he held remorse. When he grabbed me and hugged me, when I first talked to him after I went and seen him in Bogalusa, he squeezed me so tight, and he was crying and shaking, and so was I. I'm 50 years old, I'm 51 years old, I made 51 years old last month. No. And I told him that I want to live long enough to see him free again. I think he paid his due. That's not my decision to make. I don't know. That's up to you, gentlemen, ladies and gentlemen. But I tell you this here, you won't make a bad choice. I supervised 15 men. I dealt with men my age and old and young. I respect people. I come from a respectable family. We don't believe in hate, knocking other people. Tory's like that too. He just did a bad thing. He took after me. I respect people. If David Duke was in here, I respect him too. I ain't got nothing to do with what he do or how you think.
Thank you, Mr. Bates. We appreciate your testimony.
If he was here, I would respect him. If I had to work for David Duke, I'd give him the same thing I give myself for my mama.
Yes, sir.
I don't care nothing how you feel about it. It's about respect.
I agree. Thank you, sir.
Yes. Yeah.
We're
It's
gonna
not
move
about
on.
rank.
We're gonna move on
I
now.
raised my kids like that, people, and I did every one of them.
We're gonna move on now, sir. Thank you. We appreciate it.
I'm good?
Yes, sir.
Thank you very much.
Thank you,
Thank you.
sir. All right, Ms. Bronson, could we hear from you?
Good morning
Morning.
to you all. Good to see you all. Thank you all for being here and continuing to hear all of these cases day in and day out. It's not an easy job, and I feel like I say that when I come before you all, balancing a lot of different factors. We are before you, and I have the pleasure of representing Mr. Care. I have been working with him for the last couple of years, and have been talking with him and understanding the depths of what led him to this situation. And I think that we all know in doing this work, but also understanding the complexities of people, that they come into and arrive at these instances where a crime is committed and harm is done, but not in one instance. Mr. Care, despite having a really supportive family, as you heard from his father, had a strict father, had a father that demanded work and demanded that he be better than him, and all of that came with him and from his past. That translates into different ways, different cycles of control or abuse or violence that are brought up and are seen. Mr. Care has mentioned those things that he has had to figure out for himself, to what led him to killing a woman that he loved. And I say that he loved her to honor her, to bring Miss Shante into this space. I know his daughter is watching. He has multiple other children that he has relationships with. And this we have to honor her. We have to bring her into this space, and I don't take that lightly. And I know Mr. Cares doesn't, or his family, who all had a relationship with her as well. Over the past 21 plus years, Mr. Cares has devoted himself to doing the only thing that he can do. If he had the power to bring Shante back, I know that he would. The only thing that he can do is put his time in to be a different man, and to find out why he did those things. He's taken all of the required DOC courses that he was eligible for. He's taken and some. He's participated in and got certifications, his GD, all of the basics that I'm sure are reflected in the paperwork that you all have. And since his last hearing, he took what the board had to say very seriously. He's continued to work at the police barracks and gain trust. As you heard, he went from working at the Office of Motor Vehicles to now working at the training facility with the Louisiana State Police, with the cadets, and people who are in training, as well as the other officers and troopers there. He has taken Thinking for a Change, Cage Your Rage, and continued to go deeper into his sobriety plan and developing a plan by getting a sponsor, having an active AANA schedule that is rigorous, as well as facilitating a 12-week program. All of those certificates should be before the fall as well. His reentry plan is extensive, not just his family support and the parole project, but also he has employment opportunities. He has the ability to continue to get counseling, to get sobriety, to have his sobriety plan and be engaged in that for a lifetime. And I will say that in terms of being incarcerated for 21 years, he has 10 write-ups. He has been interviewed and chosen to be at the police barracks, which he has been for a couple more years since he was last before you all. And so I would say that all of that creates Mr. Care to be a kind man. He's an honest man. I've sat and listened to him and talked to him for hours about what his decision and what he did. And I know and stand before you all today, not just as his attorney, but as somebody that has come to know him, that he is deeply affected by this and knows that any chance moving forward would only be to pay a debt that he can never make up. And he is fully aware of that and also wants to continue to grow in himself, but also give back and talk to young people, and coming from New Orleans where his family is, where there's a lot of need for that. And I would say that there are a lot of opportunities and communities for support for him there as well. So as always, any questions that you all have for me, but thank you all for taking this opportunity and listening. So thank you.
Thank you. Any questions? Thank you. All right, so now we'll hear from the DA's office, Mr. Meyer.
Good morning, Randall Meyer, Assistant DA, Jefferson Parish. First off, I'd like to make a correction in misstatements, I guess, from my letter in opposition. The annual assessment stated that he still needed 12 steps, but I did then found in the progress report that he has completed 12 steps and some other substance abuse programs. And then looking at some of the other certificates, I don't know how I missed that, and I apologize for that, but there's been, quite a bit of substance abuse participation that he's been doing since the last hearing. The captain spoke very well of him, of things that he's done. However, because of the nature of the offense, his criminal history, and only serving 21 of the 40-year sentence, we'll maintain an opposition to his request at this time. If this board does decide that parole is in order, we would ask that part of the conditions of parole would be that he continue with AA treatments. Thank you.
All right, so I have some questions of you. So, Tori.
Yeah.
So or remarks. I do appreciate the work you've put in since your last hearing. I think you've done applied yourself to address the concerns that were mentioned to you. When we first got started, I think I heard you say, as you introduced yourself, I'm a recovered addict. Did I hear you?
Ma'am. Yes, ma'am.
And then I heard you say something, I think, about your AA participation, that you realize that it's ongoing.
Yes, ma'am. That's a part of me, and that will be a part of for the rest of my life. Like I say, I honor and I cherish my sobriety, and I take that real serious, because without that, I wouldn't be the man that I am today.
Right. So I say all that to say, I think maybe it's more appropriate that you refer to yourself as recovering, because you'll always be recovering.
Yes, ma'am.
Never get over it. You got to work at it every day.
Every day.
The rest of your life.
Yes, ma'am.
So tell me a little bit more about, one of the things I noted after your last hearing was there was some concern that you don't accept full responsibility for what you did. It seemed, and I wasn't on that panel, but it seemed at that time that you did lay some blame on the victim. Address that concern for me.
Yes, I have laid the blame on Shantae. I know that the 15 years that we were together, at that moment, I felt betrayed, and I knew I was wrong to feel that way, because Shantae was a good woman. She was a hardworking woman. Shantae never drank, go out, party. She never did none of that. Shantae was really the backbone holding our family together when I couldn't. I was so far gone, I didn't even realize it. And I came to an understanding that I put all my insecurities on Shantae, to blame her for all my wrongdoing that I have done. And today, I regret that, because I am to blame. I was the aggressive one. I was the one that caused everything that happened. And I am the reason why we're here today.
Okay, so let me ask you this, one other question, and then I'm going to defer to my colleagues, because I think I understand what your plan is and all of that, should you be successful. You mentioned earlier that you saw some things as a child probably should have never saw. Did you say that?
Yes, I did, ma'am.
So as I understand it, when all this happened, your 12-year-old daughter was a witness.
Yes, ma'am.
And she actually tried to get between the two of you to stop you.
Tori,
How
I
do you
didn't-
think she feels about it? What do you think that did to her even today? Have you thought about it?
yes, ma'am. She, right now today, was just like me, traumatized for what she saw me and her mother go through. And that's unacceptable. What I say today to the board, it don't justify what I did. I know I put my daughter through a lot of harm, aggravation, and every day my daughter have to live with. She have to live with. She have to live with that. And if I can undo that and give her heart closure, I would do anything to do that for Tori. Tori deserves the best. Tori is a smart young lady. She always have. And I should have never have put Tori nor her mother through that. And I regret it up to this day. Every day I have to live with that the rest of my life.
As does she.
As does Tori.
All right, I have no other questions. I'll defer to my colleagues. Mr. Prater?
I don't have any questions. Do you have any contact with your other children?
Yes, yes, I do. I talked to my son, T. Ryan Brown. I talked to DeJaneiro. I talked to my son Tyron. I do send word to the ones who I can't locate to. And I also talked to my son Jonquel. Yes, sir, I do.
Okay. I don't see any other questions, Tori, so I think we're prepared to vote, and I'll be voting first. Well, you know, I reviewed very carefully the entire record that was presented to us. I looked at real hard at what you've done since your last denial. Listened to what the captain said, and I think that the parole project is a good program that has put together a really good transition plan. I'm impressed by the fact that you've set up your sponsor and you realize that you got to do that for the rest of your life. I'm willing to take a chance and grant you parole today to that plan, long-term plan. You and do the requirement of AA meetings every week, at least twice a week. At least twice, more would be preferable, because you can help others in those meetings too.
Thank you. I will. I promise.
I'm just one vote. That's my vote. Mr. Prater?
I concur with that. I lean heavily on what the captain has to say. And so I concur with what you.
Mr. Freeman?
Okay, I was that vote she was talking about last time that I didn't think you had accepted responsibility, but today you have fully changed, and I really do believe you have accepted responsibility for what you have done. So my vote today is also going to be to grant, but I do not want you contacting Tori. If she wants to talk with you, she is to initiate it. Okay? Do not initiate or bother her unless she wants to.
Yes, sir.
You understand?
Yes, ma'am.
Up to you.
I'd like to say one more thing. I would like to say Merry Christmas. Thank you. Thank you. Hold on.
Alrighty, approved. Tori must be tow, says Lindsay. Yeah. Well, that explains the tow iPhone. All right, let's go back to Florida. Anna Garcia.
Appointing the Office of the Public Defender to represent you. Ms. Elizabeth Simpson is here from that office and here on your behalf, okay? So please listen carefully.
Your Honor, Ms. Bellamy is here for that case. This time, there's only been a complaint filed, so we've asked that she be continued. So the state can file information on her. Yesterday, I didn't get it.
This morning. Why don't we print out a copy and just take a minute? Thank you, Janae. And that way Ms. Simpson can show that. Ms. Bellamy, your attorney had not seen the information because it was just filed. And so she did not have an opportunity to show it to you. But I'm going to give her a second to show it.
Feel like we're bringing back on the 16th.
Fair enough. Are you saying December 16th?
December 16th, yes.
So are you willing to enter a plea of not guilty? All right, and we'll bring you back in 2 weeks. That way you have time to speak to your attorney. Now, Ms. Bellamy. Okay. Well, that's a hot mic. And so if you want to talk privately to your. Okay. All right. So next court date, does the state have any objection to a December 16th court date on Bellamy?
No objection, Your Honor.
All right. It will be so ordered December 16th at 9 a.m.
Thomas Bellamy, Bonifay, excuse me, was up on the screen earlier from Union CI. I'm not sure if he's still there or not, Your Honor.
Mr. Bonifay, can you hear me?
What case was this?
I did not realize that was an. Mr.
Yes,
Bonifay,
ma'am, I
can
hear
you hear me? Good morning.
Yes, ma'am, I hear you.
All right, give me just 1 second. Let me log on to Zoom.
Oh, yes.
Mr. Bonifay, can you hear us and see us okay?
Yes, ma'am.
Excellent. Mr. Bonifay, you are here in Jackson County case number 25 CF 514. Mr. Gill, do you know if an information has been filed or who's going to?
This would be Ms. Harris's case.
All right. So Ms. Harris, did you speak to Ms. Jeffcoat about this case?
Your Honor, we were waiting to ensure that the warrant had been served on this case.
So here's the situation, guys. I think I copied the state and the defense, and it was Ms. Jeffcoat. So you didn't have the benefit of it, Ms. Harris. The court does not want to transport the individual. Okay. And so we're going to go ahead and serve over the microphone today, if you don't mind. Mr. Bonifay, do you have a classifications officer with you?
No, ma'am.
I might be able to grab one.
Anybody that might be a notary or anything? Like, who's with you? Is there an officer or anybody like that?
Yeah, there's also.
Could you put the officer on the line?
There you go. Yes, ma'am.
Good morning, officer. This is Judge Garcia in the 14th Judicial Circuit. Can you tell me your name, please?
I'm Officer J. Bennett Rios.
I can't hear you.
I'm Officer J. Bennett Rios.
J. Rios?
Yes, ma'am.
Okay, perfect. Officer Rios, can you confirm for me that the inmate with you is in fact Thomas Bonifay?
Yes, ma'am.
And can you confirm that he has a date of birth of 1995?
Yes, ma'am.
White male, about 5'7", brown hair, brown eye, brown hair, brown eyes.
Yes, ma'am.
Chuck, are you able to serve with that information or is that insufficient? Officer Rios, I don't know if it's possible for us to, and tell me, Officer Rios, where are you currently housed?
As of right now, we're in Union CI. He's housed in Victor Dorm.
He's what?
Currently, we're at Union Correctional Institution. He is housed in Victor Dormitory.
Rios, we couldn't understand the last part. We heard Union CI, and then you said something about he is housed, but we couldn't understand the last part.
Victor V Dormitory.
V Dormitory. Counsels, I'd reached out to the state and the defense, because of the nature of the allegations, these are historical. This is alleged to have happened in 2023. This inmate is in max confinement. With our transport situation, for security concerns, I thought the better way is for us to arraign, first appear, and everything on this matter, okay? And so as to not create a security issue for this type of situation, that's why he's here via arraignment today. Can the state have a information filed by the next arraignment?
Yes, Your Honor, we have the.
If you choose to file it.
Yes, we have it ready, so we can file that.
All right, so Chuck, if you'll get on the mic so that we can serve the warrant, I am now going to proceed with a first appearance. Janae, I had emailed Jeannie about it, so you ready? Okay, I'm going to proceed with the first appearance on this. Mr. Bonifay, we are going to serve this warrant and we're going to proceed on a first appearance, and then we'll schedule an arraignment for next month.
Mr. Bonifay, this is Deputy Griffin with the Jackson County Sheriff's Office. Can you hear me?
Yes, sir.
Thank you. In my hand, I have a warrant for your arrest for 3 counts of battery on a facility employee. If you would consider yourself served on this date and time.
Mr. Bonifay, I'm now going to proceed with your first appearance. During a first appearance, you have certain rights. You have the right to an attorney. I am appointing the office of the public defender to represent you. Ms. Elizabeth Simpson is here in the courtroom with me and is here on your behalf. And you've heard her speak on your behalf earlier. You also have the right to understand what the charges are against you. You have been charged with 3 counts of battery on a facility employee by expelling fluids. And those are 3 different employees. It is alleged that you have committed those offenses on May 5th of 2023 on 3 different officers while you were housed at JCI. I reviewed the probable cause narratives and I did find probable cause for the issuance of the warrant. And so I find probable cause for the first appearance purposes today. Each crime is a 3rd-degree felony, punishable by up to 5 years in prison and/or $5,000 fine. Mr. Bonifay, you are also entitled to remain silent during these proceedings. Everything that you say this morning is being recorded and could be used against you. Mr. Bonifay, do you understand the first appearance rights that I have expressed to you?
Yes, ma'am.
All right, then perfect. Mr. Bonifay, I am going to, let's see, do we have criminal history on Mr. Bonifay?
Let me take a look, Judge. I did pull him up on the DOC website.
He is currently in custody.
Correct.
And therefore, in light of that, I am inclined to do the normal 3rd-degree felonies of people either in custody or on probation, which would be $7,500 bonds. However, he's in custody. His EOS is 2027. So he couldn't make those bonds anyway at this time. That said, is there any further position that either the state or the defense wishes for me to consider before I formally announce the bond amounts?
Judge, we have no objection to those bond amounts. I will just say that he is currently serving a DOC sentence, looks like for multiple felonies, one of them which is trafficking in amphetamine 200 grams or more, and looks like that was a 15-year min-man sentence, and that this did occur in DOC as well.
Is the EOS you're seeing still 2027? That's what I saw.
I'm showing 29.
Okay, I may be wrong on the EOS. I thought it was 27. Okay. Ms. Simpson, do you have anything more on the bonds? All right. Mr. Bonifay, I'm going to set your bonds in the amount of $7,500 each. As a special condition, you are ordered to have no contact with the victims in the bonds. And Mr. Bonifay, do you know, well, I don't want to ask you that. Ms. Simpson, talk to him, make sure he understands who the victims are. However, in light of his in custody status, the DOC, I'm sure, is making all of those arrangements so that there is no contact. But Mr. Bonifay, you cannot make those bonds until you EOS from your current sentence. So you can't make those $7,500 bonds now, okay? So don't waste your money. until you have EOS. That said, we are going to proceed with this case and hopefully have it resolved before you EOS on your current charges. Do you have any questions for me, sir?
No, man, that was the main thing that I wanted to know was if we could get it handled before I EOS, because I am doing 15-year sentence. I have been down 12 years already. So that's what I wanted to know and talk about right now.
Yes.
Handle it before.
So I'm going to schedule you for an arraignment next month on January the 6th at 9 a.m. And we will try to take you first. So Officer Rios, thank you. And I'm sorry that we didn't take him first. I just forgot that he was in custody. And guys, Daniel Larimore is who has been assisting in that appearance. So I would encourage both the state and the defense to reach out, and he can help with the Zoom appearance. But sir, we'll see you the very next month for an arraignment. Once the state has filed an information, then your attorney can go over it with you, okay?
Wow.
Mr. Bonifay, any other questions?
No, ma'am.
Okay, thank you so much.
Yes, ma'am.
Judge Garcia sounds like she's not feeling all that great either. Everybody in the United States is currently ill. I'm convinced of it. Texas, Judge Boyd.
Hello.
Hello, ma'am.
All right, the court is calling 2024 CR 008370, State versus Ricky Pardo. Can I have parties announced for the record?
Melissa Albin from state.
Robert Maurer for defendant.
And are you Mr. Pardo?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ricky Pardo who's placed on community supervision in 2024 CR 008370 for the offense of injuring, bodily injury against an elderly or disabled person on September 23rd, 2024 for a term of 6 years? Is that you?
Yes, it was 5 years, but yes, ma'am.
No, it's for 6 years.
Yeah, it's on, I think it's on the judgment.
Yes. So you're on probation for 6 years. Is that you?
Yes, ma'am.
All right, state.
On or about the 8th day of October 2025 in Bexar County, Texas, the defendant Ricky Pardo committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
Yes, true.
All right. Did you understand by pleading true to violation of condition number 1, I could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. We are in agreement to follow the probation department's recommendation, which is to hold him in jail until a bed is available at status on the relapse track. And then we will take into consideration the new criminal trespass. We would like to add a condition.
What is the criminal trespass cause number?
It is 2025 DC 014713. And we'd like to add a condition related to that, that the probation, that the defendant have no contact with 2412.
Ah, she muted on us. Been a little heavy-handed with the mute button today. We're a little bit in the way back machine. Let's try
Any
to bump
objection
forward.
to the court reviewing the
never mind.
court
Here we go.
summary?
None.
All right, you'll raise your right hand for me, please. Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Ricky Pardo.
All right, so what is it you need to be successful on probation? What's going on in your life?
I just wanted to show you that I can finish my probation if I just get another chance, you know?
No. That's not my question. Like, everybody wants another chance usually to finish probation. My question for you is, what do you need to be successful? So you've pled true to a criminal trespass, which means you were somewhere you were not supposed to be and somebody told you you can't be there, but you were there anyway. So what is going on in your life that you are not being successful on probation?
I was coming out dirty on my UAs.
All right, and so what drugs were you using?
Meth.
All right, how long have you been using that?
I use it sometimes, not all the times, but I was coming out dirty on my probation. That's what I was asking to go back to setup or to do the program.
And do you have any mental health issues?
No, ma'am.
Have you ever been diagnosed with any mental health issues?
No, ma'am.
Do you have any family support?
Yes, ma'am.
And who is your family support system?
My mom, my uncle.
All right. Is there anything else?
No, Judge.
This is what the court is going to do. I'm going to give you a choice. All right. I understand that the case that he's on probation for, he has some cognitive issues. And that was the cause of the case that he's on probation for. So I'm going to give you a choice. These are your only two choices. You have no other choice. One, I follow the agreement that you've reached, or I will revoke you and sentence you to 3 years in the prison. And with the 3 years in the prison, I'll recommend therapeutic community. However, I can't place you in the program because I don't have jurisdiction to do that. So those are your two choices. Continue with the recommendations that have been given, or either revoke in 3 years.
What is it, stage of felony or TDC?
No, this is TDC. Do you need to discuss it with your attorney?
Yes, yes, ma'am.
All right, if you'll discuss it with him and then just skip in line and come back and let me know. Who's ready?
Let's do a picture.
All right, we're a little bit in the Wayback Machine with that, so I'll see if I can find the conclusion. Meanwhile, let's go back to Judge West.
All right, are you Colton Armstrong? Yes, ma'am. And Mr. Armstrong was previously in court and cause number 25 DCCR 0002, entered a plea of guilty to theft of property enhanced to a third-degree felony. There was an agreement for a 10-year term to be probated for 10 years. There was not going to be a fine and $20,000 in restitution. Is that correct, that that was the agreement?
I thought it was 10 over 10?
That's what I had, just 10 over 10 with the 20,000 in restitution.
Yeah, and then I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
What is the status of the Hardin County case?
Pending.
I have made multiple attempts to contact Mr. Hopper over there to know when, I'm sorry.
Okay.
I've spoken with him about it. He doesn't, at this stage, isn't offering probation. I think what I would do, once Mr. Armstrong gets granted probation here, he would post a bond on that case and then just set it on the regular trial docket in Judge Thomas's court. And offers tend to change over the course of the pendency of the case. I think Mr. Hoffer's going to retire probably before the case will be reached for trial.
Judge, our position.
I'm not being flippant. It'll be assigned to someone else.
Yeah.
Our position on this was to make this offer obviously conditioned on the amount of restitution and his paying the restitution. As you can see, he pled to more than one paragraph, which elevated it to
Sure.
10 over 10. And we would, of course, be asking for the full 10 on the revocation.
Right, and y'all also, I guess, understand the recommendation that was made after the substance abuse assessment with regard to ISF cognitive and then JCDI after.
I would let Mr. Armstrong speak to that, Your Honor. I think in counseling with him, he advises that he thinks he's at a point now where he has a new son, new child, needs to be there for his family to support
Well,
them.
based on the criminal history and the 2 different probations that have already been revoked, if I'm gonna go along with the agreement, then I want him to have every tool to be successful. And that's what's gonna happen. So it's not necessarily meant to be a punishment, but if that's what's recommended, then they're the professionals, and I wanna give you all those tools so that you can be professional, be there for yourself, your kid, and everything else. So then, anything else?
Cognitive track or something.
Cognitive track, and then JCDI as aftercare, so there, he gets both.
The problem there, Your Honor, is that he does have a pending case in Hardin County, so I don't know that he will be able to go to that.
He's gonna have to, be, once I'm done, they'll transport him over there, because there will be a hold here, and he'll have to get that case taken care of before he goes, one way or the other.
So if he were to post bond, I guess he would still be.
He won't have a bond, he won't be able to get out in this
That's what I'm
case because
saying.
he'll have an ISF
ISF
hold.
Okay.
So, and if something happens and that case does not get resolved, file something, let me know, and depending on the time frame that he's sitting, I might reconsider, but I want to at least order that, and then we'll go from there.
Since he's getting probation here, that may impact.
Right. If it doesn't impact it and it's gonna get set on some docket that doesn't get taken care of for however, long, then just let me know. And then potentially I would hold it in abeyance, the ISF, if he has to go sit over there for a long time. Okay?
Would the court also consider imposing a trespass warning for all TNT record locations and the use of any and all of their services? I know they have multiple locations and businesses here in the area.
Just stay away from TNT.
All right, so here's what I'm gonna do, Mr. Armstrong. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property enhanced to a 3rd degree. Sentence you to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. There will not be a fine. You are ordered to pay $20,000 in restitution and to follow all of the rules and conditions of probation. Sorry, does anybody else see that? There's a bug flying around. I feel like I look crazy. You're gonna be ordered to go to the cognitive track of ISF, and then through the JCDI program as aftercare, which is an outpatient treatment program. So you'll be transported over to Hardin County. If something gets worked out once you get there, then you'll go straight from there to ISF. If for some reason that doesn't get worked out and things are going slow, Mr. Kimler will get in touch with me and we'll reconsider the ISF. I want you to go because I think it's good for you. I want you to start getting your GED. I'm going to order that as a condition of your probation. You are required to, once you're out, and there might even be the opportunity in ISF to start that, I'm not sure. But if not, once you're out, within 30 days of being out, I want you to start that program. Again, that's going to be helpful for you, for your children, to get better jobs, and so that is part of your probation. You are ordered to not be on the premises of or use the services of TNT Record as a condition of your probation also. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I don't know, I'm kind of reconsidering, with the Hardin County stuff, I'm gonna do this. Listen, hang on, listen. This is what I'm gonna do, just because I know that could take a while over there. I'm gonna hold the ISF. I'm going to hold ISF in abeyance, which means you don't have to go to ISF. So you will be able to make bond. You will be ordered to immediately start the JCDI program, but you're going to have to change your behavior on your own without that 90-day program. Here's what we're not going to do. if I give you this opportunity and you do get a probation over there and you're getting out and you start making bad decisions again, you're old enough to be making better decisions. The argument doesn't need to be to come in and go, well, now I send me to ISF. It's probably gonna be a revocation. It could be ISF, it could be a revocation, but you need to make those changes for good in your own life, take advantage of whatever probation has to offer you. Okay? All right, good luck to you. You can go back with the bailiff.
All right, that defendant has not appeared back in front of Judge Boyd yet, but we will move on to another contestant with her.
25 CR 012006, State versus Alex Sosa. Can I have parties announced?
Kim Gallagher, State.
Coronado, Commissioner Sosa.
And are you Mr. Sosa?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find the state is in compliance with discovery. Mr. Sosa, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Sosa, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Sosa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail under 1244. There's an $800 fine. State will take in consideration 2025 PF 38935. And there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am. I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, yeah.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states one an attachment.
No objection, Your Honor.
State, you may be excused. Up. Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find him guilty, and the court will find him guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Other than he's ready to start a sentence right now, Your Honor.
All right, the court will sentence you to 60 days in the Bexar County Jail under 1244. There's an $800 fine. Time and money will run concurrently. The court will take in consideration 2025 PF 38935. Is there anything else with regards to sentencing?
Nothing.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. We can go off the record. Here's the thing. If you have a drug problem, which it appears you do, once you're released from the jail, if you cannot find a place that can help you maintain your sobriety, if I'm still here, you come back here, I will pick up the phone and call a place that will help you.
Thank you.
Otherwise, what's going to end up happening, only one or two things. Either you're going to end up in and out of prison, or either somebody's going to have to identify your body because the last time you use may be the last time you use, okay?
Yes, ma'am.
All right, good luck to you. He's going into custody.
Maybe be excused.
Yes.
Thank you.
Folks, apologies. I normally do a lot longer outro, but you'll see there's a phone to my head. I've been fighting for a couple of weeks now to get my wife, Beth, follow-up care that she needs for a leg fracture, and I might actually have somebody on the phone now that will actually get me something done, so I need to continue with this call. I appreciate everybody. Thank you for joining me today. We'll be back tomorrow at the normal time. Take care. God bless.